Good evening to the learned chairman, sir. Good evening to all the learned speakers here. And wish you a very happy Navratra right now here, which is going on here. So this is the good occasion that on the occasion of Navratra, we are a very good seminar that is going to discuss here. And I hope that this Navratra will bring a new knowledge for all of us here, new knowledge, new light, and new dimension to understand the issue of law here. And these two judgments that we have picked up, although there have much has been said about these two judgments here, but these two judgments are very quite relevant here. Before we formally start here, may I request Neha Gada ma'am, who is the Vice President of the Chamber of Tax Consultant here, who can brief her to brief about the program of the Chamber of Tax Consultant here and something about the Chamber of Tax Consultant. And after that, I may request Saurabh sir, Saurabh Bhattacharya sir. I have to be very cautious about to who Saurabh sir here. So Saurabh Bhattacharya sir to speak the profile of the chairman sir and both the learned speaker here. Thank you, ma'am.
Good evening, everybody. And it's my pleasure to be here today. Thank you, Prakash Bhai. So I would just like to speak few words about Chamber. So Chamber of Tax Consultants, CTC as it is known, is a 99-year-old non-profit organization where our core objective is professional development for its members. And the focus is always on spreading education across fields of accounting, tax, and legal aspects. Currently, we are in our 100th year and we are celebrating our centenary year in this period. Chamber is also said to be the powerhouse of knowledge in the field of fiscal laws. And we have the galaxy of past presidents of Chamber include late Shri V.H. Patil, Shri Soli Dastur sir, Shri K. Shivram, Y.P. Trivedi sir, S.M. Inamdar sir, and late Shri Harish. So, Chamber also comes out with a monthly journal. It is the mouthpiece of CTC, and generally there is always a special story. Theme-based issues are being issued, and it is very informative journal. Also, we come out with International Tax Journal, which comes every quarter, once in a quarter. And CTC also conducts various workshops, seminars, study circles, and RRCs. We conduct almost 4 RRCs: direct tax, indirect tax, international tax, and FEMA. And for students also, Chamber does a lot of activities pertaining to debate competition, Dastur essay competition, moot courts, where we encourage students to come out with their skills and abilities. In the month of January, we are planning to come out with a 2-day special program for centenary year, which is a highly featured program, and I would request all of you to join for that program. The dates for that are 30 and 31st January. It will be held at Mumbai at Sahara Star. And I would not like to come in between the learned speakers and you all. Request to please take it ahead, Prakash Bhai. Thank you so much.
Thank you, ma'am. Here, for those who are not aware, that Neha Gada ma'am is the first female vice president of the Chamber of Tax Consultant, and we look forward for the presidentship, her presidentship in the next year here, when she will be the first female president of the Chamber of Tax Consultant in the history of 100 years here.
Thank
So
you.
and this is the best way to women empowerment here. I think that here. Okay.
Thank you so much.
So now I will request Saurabh Bhattacharya sir, who is our vice chairman of Delhi chapter here, to in fact to speak about the speakers here and learned chairman of this session here.
Yes, the learned chairman, Mr. Pannu, does not actually require any introduction, but just for the sake of it, whoever are new into this, Mr. Pannu graduated in 1982 and became a CA in 1985. He practiced as a CA in New Delhi till 2000 when he joined the Income Tax Appellate Tribunal, and in his long career in the tribunal till July 2024, He was an accountant member for 18 years, vice president for 6 years, and an officiating president for 2 years. He has many accolades to his tenure, to his career as in the tenure as in the tribunal. His 18 years as accountant member and 6 years as vice president, 2 years of officiating president, one of his major achievement was to reduce the pendency of appeals at all India level from 58,000 to 33,000. Uh, in addition to that, he has been active in various information technology related initiatives in the tribunal, priority in fixing and disposition of appeals, etc., and website of the tribunal improvement. All these things he has been part of. So basically, as I have told, that he does not require a formal and big introduction, but just for the sake of it, I have introduced him with the basic uh, qualities that people who might have come to this chamber for the first time will find it useful to know.
Thank you. Thank you, Mr. Bhattacharya. I think.
We welcome you, sir. Pannu,
Thank
sir.
you. Thank you. Thank you. Thank you.
Will now read out the profile of Mr. Sunil Agarwal. He also actually does not require any introduction, but again, for the sake of new members, new attendants, Mr. Sunil Agarwal, advocate, has experience of more than 3 decades in various fields of law, including direct taxes, black money law, indirect taxes, uh, prevention of money laundering, Benami law, corporate laws, etc., corporate frauds, matters involving IBC. He also handles arbitration matters, including and as has also been appointed as sole arbitrator by high courts in several matters. Apart from that, he's actually a former officer of the Indian Revenue Service, and after taking voluntary retirement from the service, he was a senior partner with AZB for more than 13 years, and he represented clients before various forums like High Court, Supreme Court, Appellate Tribunal, ED, etc., and he has been a familiar name in many of the high profile cases that have passed through the precincts of Supreme Court and High Court. So these are the basic sort of qualities that people will be finding it useful to know about Mr. Agarwal when he uh, so kindly
Welcome, Agarwal, sir.
speaks in this seminar.
Thank you, Saurabh.
And then we'll read out the profile of Kumar Saurabh Sharma. He's my colleague and namesake. Kumar Saurabh Sharma is a chartered accountant with over 14 years post qualification experience. He has worked with clients on different topical corporate and international tax issues and assisted them in undertaking compliances and reporting. He has represented clients before tax and appellate authorities and advised clients on various deals and transaction tax matters. Additionally, he has shared insights on direct tax developments through presentations to industry associations and has contributed articles to tax journals. He has also co authored a chapter in the CTC's International Tax Compendium. With this, we welcome all the three speakers, respected Mr. Pannu, Mr. Agarwal, and Kumar Saurabh Sharma.
We welcome
Thank you
Saurabh,
once
sir.
again.
Thank you.
Now, may we request Chairman, sir, to start the proceeding. This dice is yours, sir.
Oh, so I think without wasting time, we can ask the first speaker to show his presentation so he can join on the
Yeah.
issue of. So first we are discussing that shelf drilling.
Yeah, sky high, sir. MLI issue, sir.
Not shelf drilling.
Safe drilling after that, sir.
Acha, acha. I thought this was a brought forward matter, so maybe we have to do it first.
Yes.
All right. I think that has to be done by Mr. Sharma.
Yes, sir.
Part hard matter.
Part hard matter. So this can be. So Mr. Sharma can lead the discussion on.
Thank you, sir.
Die
I hope
high.
I'm audible.
Yeah.
Yes,
Yes.
you're audible.
I mean, at the outset, I want to thank CTC for giving this opportunity of sharing the platform with respected Pannu sir and Mr. Agarwal. I'm really thankful to CTC for this opportunity. And as Sir said, without wasting anybody's time, let me jump straight away into the ruling. I'll just present my screen and then we can start. Please let me know once you can see the screen.
Yes.
Yes, sir. Audible. Yes, visible, sir.
So I think Sky High Leasing is a recent judgment from the Bombay Tribunal, and before I get into the facts of the case and what exactly were the issues involved, I just want to set the stage here. Why this ruling matters is important to know, because it is not a ruling of High Court and or the Supreme Court. It is the first ruling of its kind from a tribunal, and I'm sure that this would see more litigation before the higher courts in the coming years. But why it is important to know this ruling is because this is the first of its kind ruling for this industry. So it deals with the Ireland based aircraft leasing industry. Now, we have Irish lessors who lease aircraft to airlines across the globe, and these aircraft leasing companies did not have any litigation in India in the past. And globally, also, this is the trend that they've not seen too much litigation with respect to the taxability of their income. And this is the first time I find that the Indian tax authority challenged that position, and they try to make some adjustment to the returned income. While multiple grounds were taken, in summary, there are four relevant grounds which actually the ITAT order deals with. First is the ground on whether the MLI or the principal purpose test can be invoked to deny the benefits of the India Island Tax Treaty. And I'll talk about what is MLI in a bit. I'll talk about what is the benefit which we are talking about. In addition to this issue of MLI, there are three other issues which you will see in the slides. First issue was whether the lease agreements which the Irish lessors enter with airlines in India are those operating leases or finance leases. Uh, then, when an Irish lessor leases an aircraft to an Indian airline, does that aircraft constitute a P of the Irish lessor in India, and therefore the taxability of a P follows? And lastly, whether Article 8 of the India Island Tax Treaty protects this lease rental income which the lessors are earning. And we'll talk about the quirks in the definition of Article 8. We'll talk about the importance of why operating lease versus finance lease matters here. But while I'll talk about all these four topics, I think the might I'll try that we can focus firstly on the first issue, and in fact focus more on the first issue, because the other three issues you will find there are precedents on the other three issues in the Indian context, but on the MLI PPT issue there is no precedent, and this is perhaps the first order which the court has passed wherein they have dealt with MLI PPT from various aspects. So, coming to the facts of the case, actually, this case is not the case of one SSE. It is a batch of seven appeals. But if you read the order, it is mentioned there that both parties, the council for the taxpayers as well as the revenues council, they agreed that the facts involved in all these matters were similar. In fact, the DRP orders were also similarly worded, and therefore they said that let us pick up one lead matter, and whatever the tribunal rules in that one lead matter would be followed across the board for all the seven taxpayers which were involved in this case. So the lead matter which was picked up with respect to the lease, that particular entity, it is an Irish tax resident which was incorporated in 2018. It's part of a aircraft leasing group which is leasing from Ireland and had around four companies in Ireland. These four companies included a financing company, a holding company, and two asset owning lesser companies. So the asset owning lesser companies are, you could compare them with an SPV, it is a special purpose vehicle which is set up and it only owns asset. It does not have any employees or any office in Ireland. And these two asset owning entities of this group had around eight aircrafts which were leased to Indian Airlines as well as to airlines in China and Korea. The day-to-day operations and the marketing services which they need, they were outsourced to international service providers. And the ultimate parent of the group was not in Ireland, it was located in Cayman Island. Now, the SSE had entered into three dry operating lease agreements with Indigo, which is an Indian airline, and this agreement was entered into in 2019. So if you see between the date of incorporation and entering into this agreement, there is not even a span of 1 year. And because I've used the term dry operating lease, let me also shed some light on what is a dry operating lease. In aircraft leasing parlance, you have different kinds of lease. One is a dry lease, one is a wet lease. A dry lease simply is a lease where you only give the asset to the lessee. So that is, I'm only giving an aircraft to the lessee, and the lessee is responsible for running it, operating it, managing, maintaining it. In contrast to this, we have a wet lease, wherein you give the asset along with crew, so that it is your crew which is going to operate the aircraft, even though the aircraft has been leased to the lessee. So in this case, the leases which we are talking about are dry leases, and these are not wet leases. So the year which is relevant for us is assessment year 22-23, and from these three leases which the SSE had with Indigo, SSE earned some lease rental income, and SSE filed a tax return saying that this income is not taxable in India because of the provision of the India-Ireland Treaty. And I think this is a good segue for me to talk about the India-Ireland Tax Treaty. As we know, lease rental income under the Act will likely qualify as royalty because it may be considered as a payment for us industrial, scientific, or commercial equipment. So because it is like equipment royalty, it can be taxed under the Act as royalties. The similar position would follow in many treaties because there are many treaties which India has signed that also tax equipment royalty, that include equipment royalty in the definition of royalties. However, the Article 12 of the India-Ireland Treaty is unique, even though it contains the use of the payment for the use or right to use an ICS equipment as royalties. It clearly excludes aircraft. So if you're leasing any other equipment, if you're an Irish company leasing any other equipment to an Indian party, the lease rentals may qualify as royalty. But if it is an aircraft, then it will not fall within the definition of royalty, and you would then go back to the provisions which tax business profits. The other interesting fact about India Land Tax Treaty is the Article 8, which we typically see in tax treaties, which deals with taxation of shipping and air transport. That article of India Ireland Tax Treaty also is uniquely worded because typically Article 8 deals with profits from operation of aircrafts in international traffic. An example would be Virgin Atlantic. If kind of it flies flights from India, from Delhi to London, and that profit cannot be taxed in India because of Article 8. And this is the typical situation which you'll see in most treaties. However, the India-Ireland Treaty not just includes profits from operation of aircraft in international traffic, it also includes profits from rental of ships or aircraft in international traffic. This is again a addition or a quirk or a change in the India-Ireland Tax Treaty, which is unique because it is linked to this aircraft leasing industry. In this context, because the SSE said that whatever income I'm earning from Indigo is not royalty, again, it is apparently covered by Article 8. I do not have a P in India, and therefore there is no taxation of business profits. SSE filed a return of income saying that my income is not taxable in India. But when the audit was picked up, the SSE interestingly got a show cause which said that why should I not deny this benefit by referring to the principal purpose test? I will deal with principal purpose test in a short while, but effectively it said that why should I not deny the benefit to you, because I feel that you have been set up in Ireland only to take this benefit, and therefore giving this benefit would be in a way treaty shopping, and I want to deny this benefit. This is effectively the show cause which was given to the taxpayer if you read the ITAT order. Now the taxpayer's response was multifold. The taxpayers wanted to try to argue that, see, my leases were entered before April 2020. April 2020 is the date when MLI/PPT came into effect, and it appears that the SSE was trying to argue that all transactions or arrangements entered prior to the date MLI came into effect should be grandfathered. The SSE also argued that I have already given a valid tax residency certificate, and in India there are multiple case laws wherein it has been held that you would tend to respect a TRC when you are giving or talking about giving treaty benefits to a taxpayer. The SSE also argued that if you look at my overall business, everything is in Ireland. It is only the parent which is not located in Ireland, but the group is entirely in Ireland. The four entities of the group are in Ireland. The business is being managed and run from Ireland. I have Irish directors. My bankers are Irish. My advisors are Irish, and therefore I'm actually doing business from Ireland. And why are you thinking that I'm only doing this transaction to take treaty benefits? SSE also highlighted that it is not just India that I'm leasing to. I'm also leasing to other jurisdictions. For example, I'm leasing to airlines in China and Korea. The SSE also focused that on the aspect that I chose Ireland not because of the treaty benefit, but because of the commercial advantages Ireland gives. Now, Ireland, if you know about Ireland in this industry, you would know that this industry goes back to 1970s when it was started in Ireland, and today most of the top leasing companies, in fact, ITAT notes in their order that 19 out of the 20 top Irish leasing companies in the world are based in Ireland. So effectively, SSE's response was, I have a lot of substance in Ireland, and I'm in Ireland because I want to do the aircraft leasing business from there. I'm not there just to get the treaty benefit, and therefore PPT cannot be applied to deny the benefit to me. However, the tax officer did not agree with the SSE. In the draft assessment order, the AO held that the treaty benefit cannot be given to you because your ultimate parent is not Irish. Even though you claim that everything is Ireland, the ultimate parent is located outside Ireland, and it is in fact located in Cayman Island, which is a known tax haven. They also said that while you claim that you have Irish directors, your directors are directors in multiple companies, and therefore it is inconceivable as to how they could work for so many companies and take business decisions for you. The tax officer also notes in the draft assessment order that while you claim that you're in Ireland, you have actually outsourced all your business to Irish servicers. You do not have employees in Ireland. It is an external service provider which is providing services to you, in a way doing all your business activities. And therefore, I cannot consider that you are an Irish company. And for this reason, the tax officer felt that this benefit cannot be given to the taxpayer, and therefore the taxability should be governed by the domestic tax law provisions. Now, when the SSE approached the DRP interestingly agreed with the AO on the issue of PPT, and DRP also cited that the SSE apparently lacks infrastructure or employees in Ireland, which indicates that Ireland cannot be considered as the genuine business base or business center of the SSE. The DRP also did not give any weightage to the fact that SSE was not only leasing to India, it was also leasing to other entities from other countries from Ireland. Interestingly, the DRP supplements the order of the tax officer. So, in addition to disallowing the treaty or denying the treaty benefit to the taxpayer, DRP adds additional allegations. The DRP says that now, if I look at the lease, the way it is worded and it is structured, SSE has control over the aircraft while the aircraft remains in India. And how is this control demonstrated? This control is demonstrated through a right of repossession which the SSE has. In case the airline does not pay rent, there is a right of repossession which is with the SSE. In the lease agreement also has a covenant which says that SSE would have a right to inspect the aircraft. So the DRP equates all of this with disposal, the aircraft being at the disposal of the SSE, and therefore DRP alleges that aircraft can be considered as a fixed place PE of the lessor in India. On top of that, DRP comes up with a new argument, an additional argument, which was not there in the draft order. DRP says that when we look at the lease agreement, the terms of the lease agreement, it appears that many risks have been allocated to the lessee. So even though you claim that the Irish lessor is the owner, you have effectively allocated all the risks to the lessee. The lease appears from its term as non-cancelable. The lease has covenants which say that lessee has a right to sublease these aircraft to other parties. And in view of the DRP, the lease term covers the economic life of the aircraft. And therefore, DRP says these are characteristics of a finance lease. And while the SSE is claiming this is a dry operating lease, uh, in fact, this is a finance lease. So the charter accountants among us would know the distinction between a finance lease and an operating lease. Very simply, finance lease is when you're trying to finance the purchase of an asset. You would go to a bank, take a lease, and many a times this is structured as a lease, but the test which we have to satisfy is have the risks and rewards related to ownership are they getting transferred to the lessee? And if they are, then we call it out as a finance lease. Otherwise, it continues to be an operating lease. So in this case, the DRP said when they look at the terms, they feel that this is a finance lease and not an operating lease. Uh, the, the the factors which I've mentioned, allocation of risk to the lessee, the terms being non-cancelable, the lease covering the economic life of the aircraft, these are some characteristics which typically, in fact, accounting standard 19 used to talk about. Even now, a finance lease, this is how you identify whether a lease is a finance lease or an operating lease. These are some characteristics. There are other characteristics also, and we will see when we talk about this issue that while the DRP tried to put these tests, they possibly did not apply those correctly, and that is the reason why the tribunal did not find favor with what the DRP was trying to do. And lastly, the DRP also looked at Article 8. I showed you the Article 8 of India-Ireland Treaty, which includes income from rental of aircraft in international traffic. The DRP said that when we look at the case, Indigo is a domestic airline, and this leasing cannot be therefore considered as linked with international traffic, and therefore the relief which you are trying to claim under Article 8 possibly is also not available to you. Now, while arriving at this conclusion, it appears that the DRP relied heavily on the OECD commentary on Article 8 because this is what the order of the tribunal deals with. I mean, they whenever they extract about when they are trying to rebut what the DRP has said, they have said that the OECD model cannot be applied. So it appears that the DRP apparently relied on Article 8 of OECD model. And as I said, Article 8 of the India-Ireland tax treaty is uniquely worded. It is not like typical treaties, and therefore reliance possibly on the OECD model may not be correct. So after all of this, the final assessment order was passed, wherein the lease rentals were, in the first instance, taxed as royalty under the domestic tax law provisions because the treaty was denied. There is also, because it is a finance lease, then they are also considered as interest. Without prejudice, they are also considered as interest and taxed as interest. Lastly, because the asset has been considered, the aircraft has been considered as a P of the lessor in India, DRP comes up with this 25% attribution, which is ad hoc. There is no rationale given to it. Possibly the only rationale is that when you multiply 20 with 40% rate, you come to a effective rate of 10% on gross rentals, which also is the rate of taxation under the Act for royalties and for interests in some cases. So this is in summary what has happened till the SSC reached before the tribunal. And when the SSC filed appeal before the tribunal, as I said, they took multiple grounds, out of which we had those four issues which the SSC kind of focused on, or the ITAT's order deals with. All other grounds were not pressed. One of the grounds, in fact, from the order we saw was on the limitation, and the other ruling which we plan to discuss today, the self-revealing ruling, that also deals with that limitation ground. However, SSC apparently did not press it. And these four grounds were the ones which were there before the tribunal. So when it comes to the first ground, SSC took twofold arguments. The first argument SSC took on the issue of MLI PPT was, SSC referred to the fact that there is that ruling of Supreme Court which said that whenever there is a amendment in a treaty, that has to be necessarily notified. I'll also touch upon Nestle in a bit, but in summary, SSC took two arguments. The first argument was, SSC wanted to argue that the MLI per se is not effective. So even though India signed and deposited the MLI instrument in 2019 and it was also notified then, SSC felt that after the ratio of Nestle SA is followed, we come to a conclusion that MLI per se is not effective as on date, and therefore you cannot read PPT or any other changes which MLI proposes to do in any of the tax treaties, especially in this case in the India-Ireland tax treaty. And because MLI does not apply, whatever adjustment the tax office tried to do referring to MLI, that goes away. Secondly, on merits also, the taxpayer argued before the ITAT that even if you ignore ground number one, if you look at the second aspect, even then PPT cannot be used to deny the benefit to me, because SSC felt that they met the tests which are laid down by PPT if you look at the overall arrangement holistically. So this is the first issue. So let's deal with the legality of the MLI issue, because this is the one which is really interesting. So the facts which the SSC narrated before the tribunal was, if you we know, all of us know that section 90 says whenever India enters into a bilateral treaty, it has to be notified by way of a notification. And the SSE says that India Ireland Treaty, the original treaty, was notified in 2002. That notification under section 91 is there. Then the SSE says MLI also was notified in August 2019, and in that MLI, if you in that notification, if you see that India Ireland tax treaty is a cover tax arrangement. I'll talk about the scheme of MLI in a bit, so that it is refreshed in everybody's mind. So SSE said both these are notified, agree. However, once you do whatever MLI is to do, and you come to the conclusion as to how the India Ireland tax treaty is getting impacted by MLI, that impacted treaty, or if I can use the word modified treaty, has not been notified so far. And therefore, if you look at the ratio which was laid down by the Honorable Supreme Court in the case of Nestle SA, applying that ratio, the modifications of MLI therefore cannot be read in to the India Ireland tax treaty. And before I go further, let me take pause and talk a bit about what happened in the Nestle SA. As we know that Nestle SA ruling dealt with the applicability of MFN clause and how it uh, whether you need a notification with respect to it. And a simple example, I think this will clarify or refresh the controversy and the ratio in everybody's mind. So let us say India enters a treaty with country A, which is an OECD member, and that treaty contains the most favored nation clause, the MFN clause. Now, what that clause effectively meant was, if at a later stage India enter into a treaty with country B, which is also an OECD member, and in the treaty between India and country B, India gave certain concessions to country B with respect to certain items where, let us say, the rate of tax or the scope of that income was narrower as compared to the treaty with country A, then the benefits which India had conceded to country B, they could be imported to country A. So simple example would be, let us say India negotiated a treaty with Germany where the rate on FTAs was 15%, and it had an MFN clause. Later on, India entered into a treaty with, let us say, US, where the rate was 10%. No, US is a bad example, sorry, there is 15%. Some other country, let us say France, where the rate is 10%. Now, what the MFN clause could do was, MFN clause would take the 10% rate which India has given to the country B, and it will apply it to country A. However, the practice which India was following with respect to the import of these beneficial provisions or amendment of the original treaty was, India used to notify these treaties by way of a separate notification under Section 90. So today, if you go on the income tax portal and try and download the India-Germany treaty, you will see a rate of 10%. And it will say that there is a notification by which this rate was brought down to 10%. Originally, it used to be 15%, for example. Now, the controversy which arose was whether this importation of beneficial provisions can be automatic, or does it have to be notified separately each time? And there was a different controversy as well, but that is not relevant for us. The only controversy which is relevant for this discussion is, how do you import those? Do you import and amend the original treaty automatically, or do you need a notification? And the Supreme Court, after looking at the Constitution, after looking at the manner in which India had been notifying or taking effectivizing these amendments, the Honorable Supreme Court said that notification under Section 91 is mandatory. In view of the Supreme Court, the MFN clause could not automatically lead to the benefit from country B to be imported into the treaty with country A. They said that you have to notify that through a separate notification under Section 91, and unless that notification was done, you cannot actually take the benefit which was given to country B. So SSE used this argument to say that even though MLI has been notified, even though the original Irish treaty has been notified, how MLI impacts the India Ireland tax treaty, that amended treaty is not notified. Now, in contrast to this, the revenues argument was, MLI, unlike the MFN protocols, which were a subject matter of the Nestle SA ruling, MLI is a multilateral treaty. It is not a bilateral treaties protocol. And to give effect to MLI, you have to also take care of the principle of reciprocity. And I'll talk about that in a bit. But in sum and substance, what the department argued was, MLI is different from a protocol which was the subject matter of Nestle SA ruling, and therefore, when you look at MLI, you cannot apply the Nestle ruling directly on MLI, and therefore, whatever notification India had done in 2019, that was sufficient in view of the department. In fact, it appears that the DR was asked to seek instructions from CBDT because the tribunal orders notes that the response which they are reproducing is the response which was received from the CBDT. So the position of the CBDT was that whatever notification we had brought in 2019, that is sufficient for importing or for kind of changing the India-Ireland tax treaty with respect to PPT and MLI and other provisions of MLI. I do not need to introduce a fresh notification giving these changes. And then they also talk about the fact that there is a synthesized text, which is not a legal document. So I think it will be useful to refresh how the entire MLI scheme works. So if you can read this part, ignore the bold part. Effectively, what happened in MLI was countries across the globe realized that there were few people who were using tax treaties in a manner which was not expected. So they were effectively instances of treaty abuse, base erosion, profit shifting, and therefore countries globally decided that we need to come together and try and stop this approach. And they also appreciated that you cannot have a bilateral process to make these changes effective, because a bilateral negotiation takes a lot of time, and therefore they came up with this approach of MLI, wherein what happens is that there is an MLI which is agreed, which is like a treaty. This MLI has around 39 odd articles, and then each country will call out what all treaties do they want to change or they want to impact with respect to that MLI. So the example which the ITAT has also put in their order is that, let us say India, the MLI has been signed. There are various articles in MLI. Some of these are called minimum standards. Article 6 and 7, which is PPT, is a minimum standard. That is, every person who is signing MLI has to agree to incorporate those articles in the treaties which they have in place. So India will call out all the treaties it wants to get affected by MLI, and they will submit that instrument with the OECD. They will also submit along with that instrument a list of any reservations which India has or amendments which India wants to make. So let us say MLI has 10 articles. India will say that out of the 90 odd treaties, 90 plus odd treaties I have signed, these are the ones which I want to get covered by MLI. Those treaties are called out, and then India says that with respect to each treaty, these are the articles of MLI which I want to select. Similarly, every other country would do that. So in our example, let us say there are 10 articles, and India says, I want India-Ireland treaty to be covered by MLI, and these are the 10, all the 10 articles which I want to include in the India-Ireland tax treaty. On the other end, Ireland would also submit an instrument just like India has submitted. Assume Ireland selects India, then the India-Ireland tax treaty would become a cover tax agreement. This is step one. Step two would be, out of the 10 articles which India has selected, what are the articles Ireland has selected? Let us say instead of 10 articles, Ireland only picks 5 articles. So now only those 5 articles would be matched against each other and would sail through. The remaining 5 articles which India selected but Ireland did not pick, those will not impact the India-Ireland tax treaty. So this matching exercise is done for all the parties which are signatory to MLI, and you will appreciate that it will make the entire process very cumbersome, because you need to know what are the countries which India has selected. You need to know which is the position which India has selected with respect to those countries. And you also need to know whether the other countries have selected India. You need to know whether the other countries have picked all those articles which India has selected. So this makes the process of implementing or effectuating MLI very tricky or difficult and cumbersome. So to avoid this, what OECD suggested was countries can come up with what they call a synthesized text. Synthesized text is not a legal document. What it effectively is that India will bring out a document which will summarize India's position with respect to a particular treaty. So let us say after the matching principle, in my example, those 5 articles are now to be incorporated or to be read with the existing India-Ireland tax treaty. So what India can do is India can bring about a new print a new treaty which will have the existing India-Ireland tax treaty and those 5 articles interposed wherever they are to be interposed after the matching which has been done by MLI. But the OECD stresses upon this fact that this is not a legal document, and it is only there to aid interpretation or aid the following of MLI. If you want to follow it strategically and the way the OECD plans to do it, OECD has a website which is known as the OECD's matching database. Everybody can go there. You have to pick the countries, and then it will list out whatever is the impact of MLI. Whether it will first tell you whether the two agreements are cover tax agreements. So if you go there and put India Mauritius, it is not today a cover tax agreement, and therefore MLI does not apply to that. If it is a cover tax agreement, for example, the India Ireland tax treaty, the OECD matching database will show us that it is a cover tax agreement, and these are the articles which are now implemented. So the if you read the commentary which OECD had brought, OECD was also trying to argue what the revenue is arguing, that you do not change the original treaty. You read MLI along with the treaty. And therefore, revenue said that what we feel is I do not have to, once I have notified in 2019 India's position on MLI, my job is done. There is no new notification under Section 90 which I need to bring about. But in the ITAT order, what the ITAT observes is ITAT says that if you admittedly you are trying to say that India Ireland treaty as it existed prior to MLI is going to get impacted. And the discussion now is how are you going to impact it? The ITAT notes that while India can agree with OECD and with other countries as to how they are going to negotiate and put in place the MLI process, but how the manner in which these amendments would be incorporated in municipal law, or for example, in our context, the Indian Income Tax Act, how this is going to be incorporated under the municipal law is something which OECD cannot decide for India. This is a sovereign subject for India, and India is going to take a call based on whatever is the law in India. And they say that if you look at the ruling of Nestle, there is no ambiguity which is left after that ruling, that if you want to change the treaty, then you have to issue that notification under Section 90. And until the time that notification is brought about, the existing treaty will prevail, and you cannot change the provision of those treaty. And I mean, this is what the ITAT effectively felt, and that they take away from the ruling of Nestle SA. And based on this first issue, that whether MLI applies or not, the ITAT rules in favor of the taxpayer, and ITAT gives reasons for it. ITAT says that, see, the notification of 2019, which you are trying to say is the notification which is needed as per Section 90, the positions which are articulated there are contingent. For example, the example which I gave, when India selected Ireland, it selected those 10 articles. But because there is this principle of reciprocity involved, because Ireland only selected five and five were left out, you cannot say that that notification is giving the correct picture. That notification has to be also read with what happens after the matching principles are used and matching is done. And therefore, ITAT felt that the notification which India brought about in 2019 cannot be said that it is sufficient to implement or bring the MLI changes to the existing treaty. The ITAT also...
Saurabh sir, sorry for interruption here. Now, at least at this level, now we have come to a conclusion that it was the issue which was that non-issuance of the treaty-specific notification has ITT on that ground. ITT has ruled in favor of the SSE. That is the first understanding is that part here. I just want to know that part here, because our focus is to discuss right now this issue, more particularly this issue here. I just want to know whether any argument from the revenue side on the guiding principles which was there in the treaty here, because guiding, even though the PPT may not be applicable, but the guiding principle still applies here. Is there any argument on that part here? And what was the argument on the retrospectively? Can you just elaborate on the retrospectivity part here? These two issues.
So when you say the guiding principles, you are saying that the applicability of PPT on merits of the case.
Yes, on the guiding, in the Article 1 itself, there is a guiding principle which has come in the 2003 commentary here. So we say that, and the PPT came later on here, that time here. So there are many issues here when in fact, it was discussed in the Tiger Global also, that guiding principle was complied. Guiding principle is still there, even if there is no PPT, specific PPT here. Implicit PPT was already there.
Okay, so you're saying that Article 1 would talk about, in fact, as you see, it says Article 6 and 7 of MLI. Article 6 is, uh, I believe, what you are trying to mean by the guiding principle. It says that the object of a treaty cannot be treaty avoidance, etc. But
Mhm.
the way ITAT DRP dealt with, there is no separate discussion for that object clause, the
Mhm.
Article 1 of the treaty. What the DRP did was, apparently they took both of these together. I think the first clause you would still be able to, if you are able to demonstrate that you are not doing treaty shopping, then you can very well argue that you do not fail with respect to Article 1. If it is a clear case that you are doing a commercial activity, then you are entitled to the benefits of treaty. You are right that even before PPT was introduced, somebody could come and challenge a conduit structure. But I will talk about the merits of this case as to whether on PPT can it be said that on the merits of PPT you fail. There, the ITAT found that this was a commercial operation being done from Ireland, which cannot be said called out as a sham, and therefore, at least in my mind, Article 6 and 7 are both getting satisfied when we'll move on to that discussion. Okay, and on the issue of whether it is retrospective, there is no finding of the tribunal on that. It appears that during the course of the hearing, that issue was not specifically separately pressed. So there
Mhm.
is no finding by the ITAT on that issue of reciprocity, retrospectivity. But I think uh, the view is that uh, PPT may not be retrospective. It is not that PPT, there is no grandfathering, let me use that word. There is no grandfathering under PPT. However, this ruling does not deal with that issue, and there is no finding by the ITAT on that ground which the taxpayer had taken.
If I can recall here properly here, there was a certain discussion on that part here. First part is that, okay, let's come back to this one here. Whether a separate notification as per the national judgment is required for each of the treaty to be, each of the amendment, for each of the country. The first part is that, and whether the second more important question is that whether MLI is an amendment to the treaty or MLI has to be read aside with the treaty. MLI is the intent of the MLI has to go into the text of the treaty, or it has to be read along with the treaty.
So I think I'll answer the second question first. The If you look at, an OECD has given a long commentary on how you interpret MLI, how MLI is applied, and OECD is very clear that MLI is to be read alongside the treaty. You are not supposed to amend those treaties. But if you look at
Yes.
the principles which the court said, what the court said was that is MLI's position, that is OECD's position, right? You have to effectuate or implement that position under India's municipal laws. And if the Indian Supreme Court feels that to implement or effectuate any change in the interpretation of a treaty, you need to bring about a notification. Then possibly you need a notification detailing the changes which MLI is causing to each treaty which India has signed. And I'll let me talk a bit about these pointers which I've mentioned here. The first point MLI, the ITAT said was that 2019 notification is contingent. Whatever India is calling out in that notification, that has not crystallized, because as in the example which I was taking, there are 5 articles which India chose in those 10 articles which Ireland did not choose, and therefore once you did the matching, those 5 were left out, and therefore you cannot say that whatever is written in that 2019 notification is the final position. Those 5 would still not be imported even by MLI's applicability rules. Then the tribunal also notes that if you do not notify these changes by a notification under section 90, then there is a risk that authorities may apply MLI in an unintended way, because as I said, the entire process is not straightforward. You read the existing treaty, you read India's instrument of submission before OECD, you read whatever are the cover tax agreement, you read the position of the other country, then you match whatever matches only can be imported to MLI. So they say that without a notification, there is a risk that the authorities may apply the MLI in an unintended form. And I think in the DRP order, apparently they would have used that MLI is effectively modifying treaties, because the applicability of treaty gets modified. If right now I have an Article 8 benefit, So MLI is saying that I'm still going to deny that Article 8 benefit because I'm reading the PPT test in the India-Ireland tax treaty, and therefore the ITAT notes that revenues on admission that MLI is going to modify tax treaty, this would trigger the requirement to issue a notification. And till the time you issue a notification, neither the bare text nor the synthesized text, which department also accepted, has no legal sanctity, because they said that, in fact, in the response, which I'm sure which is reproduced also in the order which the CBDT gave, there also they are listing out the process which OECD has suggested. And the finding of the in fact the observation of the tribunal was, while OECD could agree whatever they want with India, and India could also agree with that, when you are implementing that in India's law, you have to follow the law which is there in India. And after the Nestle ruling, with respect to any change which you are trying to effectuate, and even prior to that, because that is what the Nestle ruling says, that India's position has always been that whatever amendments are to be incorporated, you have to notify them. And because this notification has not been issued till date, the India-Ireland treaty, it does not get impacted by MLI, and therefore whatever adjustment the tax officer was trying to make, it goes away. And your other question, and is it only specific to India-Ireland treaty? The answer is no. If this ratio is correct, then all treaties which India has selected, in fact, MLI today for Indian treaties is not effective if I were to go by this ruling.
So we understand that by this judgment, tribunal judgment, it has a very huge ramification. This means, as of now, MLI cannot be read into the treaty. As a nutshell, that I can be said that as
Yes.
MLI cannot be read into the treaty, and MLI cannot be invoked here. So MLI cannot be invoked, which we can understand here.
Yes,
But
as per this ruling, yes,
as per,
but
yeah, as per this ruling, yeah.
as per this ruling, but as I said at the start, I think this is still a tribunal ruling, and I'm sure this is going to be
Yes, yes. That is,
balanced. And therefore,
yeah.
if we are advising clients, I mean, we should always err in the side of caution. If you are planning something, we have to be very careful as to what we are advising.
But my understanding just a bit is still there here. Like MLI was the treaty BEPS measure. MLI
Yes.
was never a instrument to facilitate any taxpayer. It was there to curb the tax planning, to curb the loopholes here. So therefore, BEPS, the MLI was for the BEPS measure, and particularly Article 6 and Article 7, which the minimum standards are there, which was implemented in a side-by-side manner here. It was never saying that the treaty will be get amended here. Subsequently, if you can say that after MLI, some treaty has already been signed. Like take a case here, after MLI, China treaty has come into force here. Like Moises amendment is coming here, even though after MLI. So they are saying that Article 29A will be a separate and part of the India Moises treaty that will be notified through the treaty. That will be notification here. So Article 29A, which was it was the PPT clause, is coming to the India Moises Treaty through a separate notification because it is amending the treaty here. But MLI per se is not amending the treaty. MLI had to be read this treaty here. This is the first understanding that part is there. Second part is that the CBDT has issued the notification wherever the tax benefit has been extended to the taxpayer here. Here only issue was there, the BEPS has been applied here. So still you feel that the notification is required? I'm talking about the pure academic point of view. Do not see that it was the case that we are trying to understand here. Now we have understood, because main issue of the thrust of the case was to understand the MLI implication here. Now we have come to the totally discussion mode here on the legal implications here, how to read the MLI, whether the MLI can be, whether the MLI is a separate instrument or MLI is the protocol under the treaty.
So, I mean, I agree with you, sir, that academically, if you were to look at MLI, and the position has, as I said, has been canvassed by OECD itself. If there is a need to notify, every country needs to go back and notify each bilateral treaty then which they have entered. Possibly, this is going to undo the what you are trying to achieve by MLI, right? What you are trying to achieve by MLI is that there is one document which you sign, and then every country files that in. Then you do that matching principle and you come to a conclusion. And then and you're right, the intent is always that you have to read it along with the treaty. You're not supposed to modify the treaty. But the fact is that at the end of it, you are still changing the way a treaty impacts me. While you write that the MFN notification talks about some benefit being given to the taxpayer, if there is a benefit you're taking away from me, that also should ideally be notified, because Section 90 says that you can enter into a treaty with a foreign jurisdiction with respect to taxability of an income. Now, whatever I have entered with Ireland with respect to taxability of that income, that would get changed. And the way tribunal looked at it was the fact that Supreme Court had laid down this very clear law. You need to issue a notification in the official gazette whenever you are trying to change something which is already been negotiated, or if there is a new thing which you're negotiating. The reason why they have to do Mauritius outside of MLI is because Mauritius is not a cover tax agreement under MLI, if my recollection is correct. And because it is not part of MLI, India cannot, I'm sure India would have included Mauritius also in the MLI notification, but because possibly Mauritius did not include us, it never became a cover tax agreement. And therefore, India has to now go out of MLI and copy Article 29 of the OECD Model Convention, which is effectively Article 7 or the PPT, that in the India-Mauritius Treaty, which we are still trying to negotiate. I mean, that bilateral negotiation is going on, and we are not sure when that is going to get implemented. But the sole purpose of MLI was they wanted to do away with that long and arduous process of bilateral negotiations. And
Just to supplement, Mr. Sharma, Prakash, see, one must appreciate the logic which has gone into that decision making. So the conceded position of the board also, which I see from the board, from the order, is that they are saying that MLI is not an amending protocol, but it's a modifying, it's something which modifies the existing treaty, which is, echoed by even the understanding given by OECD. And as Mr. Sharma explained, that MLI is a multilateral instrument, and to cut down and to cut short the time period involved in coming to implement such commonly accepted principles, what they proposed was that at one platform you can put forth as to what all the points which you seek to cover. The other party may respond. For instance, in Ireland's case, Mr. Sharma has explained out of 10, 5 have been accepted by the Ireland. So therefore, but nevertheless, in the entire thing, there is something which is called an agreement. So there's an agreement on those 5. MLA agreement is there on 5. And now what the courts have said, starting from Nestle, and what the tribunal also reinforces, that once having come to that agreement on the platform of MLI, then to implement such agreement, your section 91 requires a notification. That is why, that's the reason perhaps they have taken the view, and which they have again amplified by Supreme Court, because what they say is, by notification, the official gazette makes such provisions as may be necessary for implementing the agreement. So it's not a question of simply notifying whether to understand whether it's an amendment to a particular treaty or it's not an amendment. The point is, you may use the word amendment or a modification. In fact, there is not much difference, but at the same time, it has the level of an agreement. And Act uses the term agreement. So if you agree to those 5 in between the two of you, it would still be caught by the requirement of subsection 1, where it says, and after 91 A to D, A to D, and may by notification the official gazette make such provisions as may be necessary from implementing such agreement. And that is why Supreme Court was pained to explain that the government or the union can, of course, enter into agreements, but it is the parliament which will have to do the notification part of it. So therefore, that is the requirement which has gone into that purpose. So that perhaps has weighed with the tribunal also to say that after having understood that this multilateral is in operation for a particular date, but all the same, in individual country, it is left to the individual country to then see how it is to be implemented. And implementation is what has come in between of application of the such MLI position. And board board says it has argument of the board is that our writing or our joining the MLA itself is section 91. Well, then, if that cannot be the position, obviously, that has to be understood in the manner which is required by 91. That's what Nestle says. So that is where one has to make a distinction. It is nevertheless an agreement on those 5 points. And that agreement needs to be implemented through a notification of 91. That's how I understand. What do you say, Mr. Sharma? You have been into this. In fact, you have piloted this.
No, sir, I agree. And the in fact, one takeaway for me from the order is it appears that the DRP relied on the synthesized text. I mean, while the CBDT is today saying that synthesized text does not have legal standing, because if you see
So
the
that's a departure from what the revenue authority does.
exactly,
And
exactly,
I would rather compliment the bench to say that they have taken they have taken the steps to ensure that the view of the board or the view of the ultimate view of the board should come into the picture, and that is what they have considered also. The board has rightly taken a stand. I mean, but then the point is they can't put the clock, I mean, back in the sense that 91 subsection 1's requirement of coming out of the notification, even for an agreement to be implemented, is staring in their face. अग्रवाल साहब आप क्या कहते हैं?
Sir, thank you. In fact, it has been a very absorbing kind of presentation by
Yes,
Saurabh
certainly.
ji, Saurabh 1, Saurabh 2. अभी मैं distinguish नहीं कर पा रहा हूँ, but
That's why
दोनों ही Saurabh
that's why I went by Mr. Sharma only.
Mr. Sharma only. So it is very engrossing. Only two basic points, and one on this MLI point, but after this I will come to something which is very different, because this Ireland lease and finance lease, etc. I come because this is the matter which I am handling. I created this matter in the High Court. We have some 200 matters batch, which so I will come to that. And perhaps in that context, this MLI issue may not be relevant in this case, at least in this case. Anyway, so I think the way I would agree with Pannu sir, and I would just refer briefly to the background. All of us know BEPS. There was a relevant action point. It was divided into action points. And when I think action point 16 or something it was, which said that changing the treaties, all the treaties, that was some 3,000 treaties plus, they were required to be bilaterally amended. That was the problem. So, and this view was that changing these many treaties bilaterally will be taking years. Therefore, this MLI was considered that some kind of a common thing. Now, I will just give an example, and Pannu sir can appreciate the best. If there are 10 assessment years of one assessee, now ITAT is very well entitled to pass 10 different assessment orders per assessment year. Or the ITAT can pass one consolidated order for all the 10 years. I don't think there is any difference in legality. It is only an administrative convenience. So to my mind, this instead of individual amendment to bilateral treaties, if we signed this combined instrument called MLI, this was only an administrative convenience. That is one part. Second part is that it has the same effect which would have been achieved by a bilateral amendment to the treaty. So it is an amendment. Nobody can dispute. It
Good
is an
that you
amendment.
admitted it. Good you're saying that. I agree with you. It's an amendment.
It is an amendment. It cannot be otherwise. It cannot be otherwise.
But it's an agreement. That's why I use the word agreement. That nevertheless, it's an agreement, whatever you may use.
Sir, because you are so thorough, I mean, and I enjoy putting something which may make the discussion more enriched. That, the point is that, section, all of you must be knowing that the treaty is always through the executive power of the government. You know, the state has got three wings: executive, legislature, and judiciary. Now, in every country, treaty making is a part of executive one. But and that's why it is called an agreement. Now, the treaty has to once the treaty is signed, the municipal laws of the country, I mean the courts in India, they will not recognize this treaty which has been signed by the government of India in executive capacity. It has to be internalized in the domestic law of India, and this mechanism is called Article 253 of the Constitution.
Absolutely.
253 के थ्रू लाना पड़ता है, ठीक है। नाउ दुनिया में 193 कंट्रीज हैं जितने यूएन के मेंबर्स हैं, 193। नाउ एवरी कंट्री हैज गॉट इट्स ओन प्रोसीजर हाउ टू इंटरनलाइज एंड incorporate the agreement into the domestic law of the concerned country. As an example, in America, it is the Senate which has to approve. What the US President, Mr. Trump, might sign with India, let us say, it will have to have the approval of the Senate. Senate means the parliament there. So that is their internal procedure. In some countries, I mean, UK also, it is a parliamentary approval. In India, we have done that. The parliament, by a statute called Income Tax Act, in section 90, has delegated that power to the executive to bring that treaty into the domestic law through a notification. That is that section 90, subsection 1. So, so every country has a different procedure. Now, once it has come into through that, it becomes now the Supreme Court, High Court, Tribunal, everybody is bound to take cognizance of it. So that I am not, but I mean, I would, I do not have any difference. That this is an amendment to the treaty. And if amendment to treaty requires to be notified for enforcing it, then perhaps, in principle, that ITAT judgment is, to my mind, is right.
I have not, in fact. The logic is well taken there, that logic. Question is of taking the logic, I think. That logic is well taken. Because you may call it amendment, you may call it modification. Question is, there is an agreement between the two countries. And now we are looking for its implementation. Is it there as per the municipal law of the country, which is the Income Tax Act 61, as Mr. Agarwal explained. So there, probably, that is where the fault has been found by the tribunal, factually speaking. And one thing more, Mr. Agarwal, the stand of the revenue, I think they have rightly captured it. But the only, on substantively speaking, if we issue MLIs on 10 different points to a common OECD structure, whereby the other reciprocating country comes in only with 5. So the word agreement will apply only vis-a-vis those 5 only, not for the complete 10.
Yes, sir. Because
so therefore, it would be necessary for the Indian country as such to thereafter recognize those 5 only. And there is in fact in the board, I have seen the stand of the revenue. There is a vacuum vis-a-vis admitting that position as to how did they. So even if one takes an argument, look, 91 is certified because maine to, as you put it, look, we did a consolidated thing. The board says we did consolidated, तो हमने उसको एक administrative convenience मान के उसी को 91 मानते हैं, हमारा कहना ये है. This is what they're trying to say. No, but vis-a-vis those, it has to be only vis-a-vis those 5. That consolidated one is vis-a-vis 10, which you put forth with the India as a country put forth in the MLI this thing.
So I think if I understand you correctly, what you are saying is, let us say there is an agreement between, say, you and me. Let us say.
That's right.
And this agreement has run into, say, 5 years.
Right.
After that, we think that some modifications are required to make it aligned with the current changed reality, let us say.
Right. Say MLI.
And so, I'm just giving a very practical, common sense example, just so that everybody, every participant, perhaps easily understand that.
That's right.
So now, I make, let us say, I make 5 proposals to you for your consideration. Maybe you make 4 proposals or 6 proposals for consideration. Now, both of us think over, sit on the table, and then discuss one by one, one by one. Now, some proposals, let us say I propose 5, you propose 6. Some proposal, let us say 3 proposals, where you and me meet. We
Correct.
meet in the mind, add item as we call it.
Correct.
Immediately accepted.
Correct.
Now, बैलेंस अप टू पॉइंट ऐसे बचे जिसमें पार्टली आप हमसे एग्री कर रहे हैं, पार्टली नहीं कर रहे हैं, मान लीजिए।
Correct.
तो ऐसी स्थिति में वो वाले जो पॉइंट्स है वो
Yes.
to the extent of agreement will be incorporated. To the
Yes.
extent of disagreement, they will remain unchanged.
Correct. So for that matter, you need to have a separate document to say, look, these 5 are implemented.
So I think
Which
now
is missing in the entire thing here.
No, it is there, sir. Of course,
Achha.
it has become slightly cumbersome. What has
Okay.
happened? I mean, because I was a very,
Because we are going by what the facts are emerging from the order at least. So we don't know the benefit of that. In fact, that's good that you were. This is very nice.
So that VEPS came in I think 2016 or 17. I was a part of that through IFA and through other these mechanisms. So now then, because this was a purely administrative anyway. So I mean, I know the background and how it is panning out that now you people are sharing with me. So now my point is that we have one MLI. And India, to my mind, must be having around 90 or 94 full-fledged double tax AA, DTAA, कुछ ही कहीं लिमिटेड भी है। तो अब 94, 95 हमारी ट्रीटीज है। अब हमने हर एक के साथ उसको किया। नाउ बेसिकली झगड़ा कहाँ था? वो डबल नॉन टैक्सेशन का था झगड़ा, जिसको हम आर्टिकल 6 बोलते हैं उसका MLI का। डबल नॉन टैक्सेशन वाज द ओनली इशू। एंड नंबर 2 दूसरा इशू था less than minimum taxation.
Correct.
These are 2 points. और झगड़ा कोई खास था नहीं, क्योंकि सिंगापुर और मॉरिशस को मैं TT नहीं समझता। That is an economic kind of a corridor created by the government of India for economic reasons. वो जो capital gains वगैरह का था, वो that was a different reason. Otherwise, every treaty is basically an economic agreement, I would say. भैया मैं आपको इतना बेचता हूँ, आप मुझे इतना बेचते हैं, आपको इतना फायदा होता है, मुझे इतना फायदा होना चाहिए। दिस इज द बैकग्राउंड फॉर ए ट्रीटी। It looks like dry on the paper, but in reality, those who have negotiated, they have calculated कि इंडिया से यूके से इंडिया में बिजनेस 5,000 करोड़ का होता है, लेकिन इंडिया से यूके को 6,000 करोड़ का होता है। आपको इतना मिलता है, मुझे इतना मिलता है, तो मुझे यहाँ पर इसकी बैलेंसिंग करनी है। This is what is real thing. Being a former bureaucrat and part of income tax.
Very nice. No, good that you are able to share all this. In fact, it's very good.
So this is the way it happens. So anyway, just coming to the basic point, and Prakash ji, please correct me in case I have missed the point. That so, sir, I mean, this was your point also. So basically, I think the point is that the two parties partly agree on certain points, partly disagree. MLI synthesized text, to my mind, is the ultimate outcome of the treaty which was earlier existing as modified by the MLI synthesized text to the extent of agreement.
Correct.
To the extent of disagreement, the old treaty continues on those articles.
Correct. So now the synthesized text. Now so that we have already spoken about, that once this happens, then there is this modification or an amendment that has to follow the local laws. That is where the whole issue of Nestle in India comes in.
In fact, सर थोड़ा सा मैं इसमें बस एक पॉइंट ऐड करूंगा कि इसमें जो एक्चुअली नेस्ले में इशू थोड़ा डिफरेंट था। वो थर्ड पार्टी जो था ना, थर्ड पार्टी का वो लेके आ रहे थे कि that somebody who was not a member of OECD earlier later became the OECD member, then extension through the back door, वो सब इशू ज्यादा थे वहां पर। वो इसमें ये इशू नहीं है। ये तो to my mind notification is, देखिए, as all of you know, this is delegated legislation. Parliament has expressly conferred this power on the central government by delegation. Delegate ने अपना नोटिस निकाल दिया। तो मतलब जब what I mean to say है कि अगर पार्लियामेंट का डेलीगेट है सेंट्रल गवर्नमेंट ने ट्रीटी साइन कर दी, उसकी कोई दिक्कत नहीं है, लेकिन वही डेलीगेट नोटिफाई करे ना करे, उस पर दिक्कत हो रही है।
बट जब सब मानते, वो तो आपस में मान के दे आर ऑल एग्री कि अमेंडमेंट है ही नहीं.
So
You see,
that is
they're very.
Sir, I have one submissions here, sir. Like
बताइए.
synthesis test is not a legal document. Synthesis is not a legal document which the CBDT has fairly accepted this part here. There was no obligation to issue the synthesis test also.
Yes.
There was no obligation here that the CBDT should issue the. It has been issued only for the administrative convenience. There is no legal requirement also here. So the point arises here, once they have entered into an agreement of the MLI, which can be covered into the section 91, and whether they, now we have two agreement here. One is the DTA, one is the MLI here. MLI, can we say that, yes, we have to read both the together here? That is the first part that I'm trying to say here. And MLI is not the outcome through a notification, through a protocol here. So can I say that there are many cases where through the protocol there has been some amendment, so there is a notification is required here. Can I say that MLI itself is governed by section 90? So there was no, and it has already been notified. Once CBT has already been notified, so there was no specific requirement of each country notification. This is the one of the argument which I'm trying to understand from the student point, from the legal point of view, sir. One more point of this one, Prashant Maharshi sir has written in the Q&A box here. He says that what is the provision of the act for notification? There has to be an agreement. MLI is an agreement which has notified. So nothing more to be notified further. SC was in the past practice, SC was in the past practice, country practice, etc. So he assumes that he is of the view that MLI was already notified, so there was no separate notification is required here. So these are the few submission that I wanted to make, sir.
ये अच्छा पॉइंट किया आपने. जस्ट मुझे क्योंकि आई कुडंट, ये MLI has been notified under section 90 subsection 1 MLI.
Yes, sir. Yes.
So the notification is that overarching notification of 2019, wherein India has said whatever changes they wanted or expected out of MLI. But as I was explaining, that is not final, because then the matching principle applies on that notification, and you come to the end of, and the department's position is that we only had to do that 2019 notification, and therefore there was no need for any other notification once that has been notified.
Just sorry for my understanding, sorry to bother you. I mean, my illiteracy here. What I'm trying to say, 2019, I have not seen, because I mean, these litigating lawyers, we see past matters, new matters we rarely see. So these things have not yet come to my notice. So this has been notified under section 90 subsection 1 of Income Tax Act. MLI?
Yes, sir.
Yes, sir. Agarwal sir, Prashant Maharshi sir want to talk.
The difficulty is what they have notified is what MLI India has given to OECD, not the agreed ones. Mr. Sharma, am I right in there?
Yes, yes, sir. It is what India has submitted. How
but
it gets.
Yeah.
So let me add, the intent of OECD was never that you have to notify or you have to come out with what is the final outcome. That is the entire construct of MLI, that you only submit that instrument of ratification which you have to give. Each country will submit that, and then a matching will be done. After the matching is done and the treaties would effectively get amended or altered, there is no need to, if you go with what OECD is trying to do, there is no need to notify any amended MLI, because let us say India, in my example which I was taking, 10 out of 5 with Ireland, but possibly 8 out of 10 with Japan. So you can't, either you say that I would notify each separately. You cannot have one overarching notification which would suit all treaties. If India has to notify in India's mind, you only need to notify that one notification which was done in 2019. You can't have a scenario that how that notification gets impacted by each country's submission. That may not be practically feasible.
No, here's
No, but the point is, Mr. Sharma, if
Sir, Prashant ji, sir, namaskar.
Namaskar, sir.
Prashant, why don't you come through?
Sir, I don't have the video.
No, you have the video.
I'll be there.
You have the video.
Sir, my view is whether video is no video, sir. Provisions of section 90 is to be looked into. The provisions of section 90 says that the central government may enter into any agreement with the government of any country
country.
outside India. There may be one country outside India or there may be multiple countries outside India.
Yes, yes.
Okay, sir. Then it has to be notified in the official gazette for
Mhm.
implementing the agreement.
Correct.
Multilateral instrument is an agreement of India
Mhm.
with multiple countries.
Correct.
Correct. So that is the agreement which needs to be notified.
Correct. So my no
That
no
has been
agreed.
notified.
Agreed.
So
No.
nothing more is required to be notified.
No, no. Let's start from where you have let off. You
Yes,
see,
sir.
MLI say those 10 points went for a country. For the other 19 countries separately, all the points went into MLI, notified and sent to OECD. But the
Yeah.
other countries have to reciprocate out of those points.
But at
It's
that
all
time, there is no agreement entered into.
so therefore correct. So that is why you
Huh.
need a notification to
Sir,
implement.
sir,
That is why that is
that
why
is
the
the only matching of the clauses
correct.
of the multilateral instrument.
So therefore,
Multilateral instrument, India and
no,
Ireland both have
no,
agreed.
no, no, but no, no. Only on those points where you agree. What is
No,
right to be
no, no,
what?
sir. Sir, perhaps there is a difference of opinion on this issue. That
No,
what
no,
is
no. What?
required to be notified,
Because
and
can you notify something for which you know
presumably, presumably,
presumably
sir,
where other country has not agreed, you cannot implement
presumably,
it.
presumably, let us take the view of the tribunal that Article 6 and Article 7 of MLI is to be separately notified. Okay. But only agreement can be notified. Where is the
Correct,
agreement?
correct. No, no, correct. So out of 10 points raised by India in the MLI, if there is a consensus or agreement on seven, those seven
There
will have
is
to be notified because
so
only those seven can be implemented. And notification, what is required is section 91 is only for implementing that agreement.
no,
To
no.
implement,
Then because
so,
sir, first condition is that central government must enter into an agreement.
so
Central
the
government has already entered into an agreement by
agreed.
for incorporating Article 6 and Article 7 of MLI. No
Correct.
agreement is required. So
Ishan
if
bhai,
there is no, sir.
this was the same position vis-a-vis and Nestle also. There was an
No, no.
earlier agreement with an earlier country which was notified and entered by the central government. But the second agreement with the third country necessitated some amendment or some modification to the earlier one,
Sir, I will come to that
isn't it?
later on. That whether Nestle relied upon by the decision is also an issue. Nestle was
Uh,
decided on the basis of country past practices, the
True.
earlier methodology. Where is that particular fact coming into the
No, no.
MLI?
But Justice
That is
Singh,
also an issue, debatable.
Justice agreed. Justice Singhvi, but also not only said about the past practice, he said the past practice was because of what the requirement of section was. That is the reason the past practice was taken.
Mhm.
So therefore, that notification vis-a-vis on section 91. So therefore, they said, no, no, the second agreement has gone into it, and first agreement already was there where you could apply this rate, but it cannot be implemented. It requires a notification because of section 91, and this is what India has been doing earlier also. That is why this past practice. So in this case, my difficulty is that if MLI is sent by India and which has formed into a synthesized version of the whole amendment or the modification, now you have to implement that. So that is why Supreme Court laid out two different things. One is agreement, as you rightly said, has to be notified, and thereafter there has to be implementation of it. So this is an indirect way of agreeing to the other countries on a common platform, MLI or OECD platform. But the implementation part, that's why Supreme Court borrowed by a tribunal saying that look, now the municipal laws of the individual country will govern the implementation part, for which this notification comes into picture. That is the whole logic taken by the tribunal.
And sir, if I may, I like to add to what Panu sir said, Mr. Maharishi, that see, you're right. The Supreme Court ruling in case of Nestle says that I'm looking at past practice, and therefore, if I go by past practice, but can it be a scenario that we are saying whatever practice department follows that becomes law of the land? I think that practice also needs to get sanctity from some section or some provision of law. In this case, section 91 was the one which was actually giving the government or the department that power to issue those notifications. You have to marry those two together, and if that rationale is right, possibly the way ITAT has tried to apply that to this at least to my mind, also is correct.
Well, let us see. I think maybe both. I mean, just help me because slightly I am not up to date on that. My understanding is that after the BEPS plan was finalized by the OECD, India took its position, and I know what they took. Basically, Article 6 was adopted by them.
Yes.
Let us say there was a clause in BEPS that the taxation dispute shall be settled by arbitration. That was one of the points which India flatly rejected.
Yes.
So, I mean, just an example I'm saying, India flatly rejected. We will not accept arbitration in taxation. So, in this way, India deposited its instrument of ratification, what they call it, with the OECD office in Paris. I remember Mr. Arun Jaitley, the finance minister at that point in time, he had 23rd June 2000 something 17 or something, if I remember correctly. That was
So
the time.
in 2019, sir, we submitted that with OECD, and we also notified what we submitted. So that document, that position of India, as you said, has been notified. But what
Notified means under, sorry,
91, yes.
91.
Yes, yes.
So to my mind, then, sir, I mean, then the requirement should be treated as satisfied of notification. Because what is happening, देखिए आप सब लोग learned members ITAT के हैं और advocates हैं. एक बात बताइए, एक सेक्शन 164 इंडिया उसमें है इनकम टैक्स एक्ट में, उसमें लिखा हुआ है कि जो बेनिफिशियरीज का शेयर होता है ट्रस्ट में स्पेसिफाइड होना चाहिए, ठीक है. स्पेसिफाइड के दो तरीके लिखे हुए हैं उसमें. एक तो ये कि ऑन द डे द ट्रस्ट इज क्रिएटेड द बेनिफिशियरीज आर आइडेंटिफाइड बाय नेम एंड देयर स्पेसिफिक शेयर इज आइडेंटिफाइड. दूसरा मेथड ये है द नेम्स एंड शेयर्स आर नॉट आइडेंटिफाइड बट द मैकेनिज्म इज लेड डाउन बाय विच द शेयर्स कैन बी आइडेंटिफाइड इन फ्यूचर. Now here, because every country will deposit its instrument of ratification with the central registry, that is the central registry, like a clearing corporation in India, clearing house type. So they will see that this country has accepted this, rejected this country accepted, rejected this. They will make a comparison, the DV kind of document which we make every day in the office. And then so after matching that, this so-called synthesized text comes into being. So therefore, I mean, the way I read it and the way I understood it, that there is something called, there is a plain paper, old treaty, and then we put a stencil of the matched principle. So old treaty has to be seen against the new thing. So therefore, the synthesized text is just a aid memoir. It is not a new treaty. Otherwise, you can do very well. This is the old treaty. These are the clauses of it which have been changed. So you read them side by side. Something like that. Otherwise, that is an administrative. But to my, I mean, once let us see into that, because then the requirement at the end of the day, Government of India is only going to issue it. Maybe we are going into too much hyper technicality. That may be another view. I mean, that of course the higher court will do that.
Yes. To that extent, you're right. Like Brother Maharaji has also said that this MLI as such, which has gone with multiple countries being notified in one, that also is the notification. But the point is, even Supreme Court in Nestle also in these conclusions, they have said so. It does not automatically lead to integration of such term extending the same benefit in regard to matter covered in the double taxation agreement of the first nation, which entered into double taxation agreement with the India. In such event, the terms of earlier double DTA require to be amended through a separate notification. Now, the debate is whether the separate notification can be taken to be the one which is sent as a MLI notification 91 for all the countries together to OECD, or it is only the synthesized version which was specifically agreed to thereafter between the countries is required to be thereafter notified, because it could be different from what the notification has been sent for the multiple countries. That is something which is the debate.
But sir, I think
sorry to interrupt, sir. Sorry to interrupt. One more participant, Mr. Vijay Goyal, wants to.
Yes, उनका था कुछ. Yes.
Yes,
please.
Mr. Goyal, sir.
Thank you, Prakash ji. Sir, I think the first instrument which is submitted by the respective countries to the OECD that is actually is to be perceived as a proposal that these are the terms actually which are acceptable to us with respect to different countries. So once the corresponding country admits that, agrees to any of that, like you said, 7 out of the 10 are accepted. So on those seven, it takes the shape of the agreement, or you can say addendum to the agreement, because there was an agreement earlier. So now, as rightly read in 90 subsection 1, it says they will enter into agreement and may, by notification in the official gazette, make such provision as may be necessary for implementing the agreement. So first of all, there has to be agreement and then the implementation. So agreement concludes once the other country accepts the relevant parts of it. So now once the agreement is concluded, so there is a need for the implementation notification. So this is how I read it, sir.
Yeah, I think
So
Vijay,
only
you have a good point.
only fact finding which we needs to be seen is we have to actually see what that MLI notification is. Is it notified after the countries having arrived at that thing?
No, no, sir. This is the notification wherein India submitted its position on MLI. So the matching principle, the matching is done on that notification. It is not the final position. So
So
I
it
think
is so after matching there is no notification.
no, no, no. There is not. Sir, as I said, that is not the intent of MLI. It was never expected. See,
No, we are
possibly.
only from the point of view of implementing vis-a-vis the income tax
Yeah,
under the
yes,
Income Tax
agree.
Act.
Yes, yes, agree,
So,
agree.
so whether
In
we can
fact,
say that it lies notified under 91, even where there was no agreement on that point.
in fact, I quite like the way Mr. Goyal put it, that possibly you look at that notification as a proposal by India and not an agreement, because agreement would be once the other country has also put and you attain some finality. I mean, that is a very novel way of putting it.
Prashant Bhai, can we look at it like this? You see, notification for implementation in 90 subsection 1 is for something which needs to be implemented. Now, if that there is no notification separate after having reached the matching principles for something which is unmatched, will 91 cover such a notification? Because 91 says where there is an agreement which is notified on a historical date. But for amendments thereafter, modifications thereafter, the protocol thereafter, they also have to be agreed. Even the protocol, though supplementary to the agreement, is an agreement which is arrived at later on but notified under section 91. That's what our board has been doing. So can you take that notification 19 as the one which does not bring out the matching agreements? What do you say on that? Will that still be a notification as 91?
Sir, according to me, the agreement of MLI is the agreement between one country entered into with multiple countries.
Correct.
So that
Agreement.
is the
No,
agreement.
agreed. But
And
is that an agreement on the date when you sent your proposals or when it got matched?
sir, it was never a proposal. Everybody, all the countries agreed on a minimum standard and other standards. So there is an agreement between all the countries, and every country deposited their multilateral instrument with the OECD bank. After that, OECD did the principles of matching, that they were matching it. All the countries agreed on the multilateral instrument. So there is a country, India, which has entered into a multilateral agreement with 93 countries. So
Correct.
the agreement is already there. There is nothing left out.
No, but those specific, supposing 93 countries the other country we are talking of, has not agreed to India's position on 10 or say 2.3 points. Can we still call that as an agreement?
Yes,
To
sir.
that,
Everybody agreed. Everybody agreed on a minimum standard. Everybody agreed on the other agreements, other clauses of the
So
MLI.
you mean to say,
They
there was no unmatched things.
no unmatched things. Everybody agreed. So agreement is there. Now there is no further agreement. Now
No,
there
but
is no further. Suppose if the matching is done, then India does not enter into any agreement with anybody on the matching.
Hmm.
So if there is no agreement, what is the need of notification? That is one way of looking at the things.
Correct. But if
Only
there is an agreement partially and not partially, as Mr. Agarwal was giving that example, then what
uh,
is the position?
no, sir. All the clauses of MLI has been agreed by all the countries. Now each of the country has deposited their document that with which country what clauses of this agreement will apply. Agreement is already in the place. There is no finding in the order of the ITAT. There is no argument of the SSC, no argument of the CBDT that anything further is required to be agreed upon. Everybody is agreed that. So therefore, once the notification has already been issued, the issue is whether once again a notification is required. And if
Sir,
it is
that is,
required, if it is
Sorry.
required, it will create a worldwide chaos. That
No,
is
just,
one
just,
view of
I
one
think
way
we
of.
need, I think we
just a
need
small point.
we
Just a
should look
small
a
point.
presentation on this.
Just a small point here. That in a MLI, I think how many? Some 16 points are there.
So there are
16,
I think there
16
are
or 17.
39
Yeah.
clauses, but all are not relating to income. I mean, some are
Uh,
procedural.
yes, correct,
Arbitration
correct.
issues, leave the arbitration issues
Yes.
apart.
Now, number two, BEPS had got some 16, 17 action points. Now, not every point was agreed by every country.
Agreed.
Yes.
Some countries were accepting few, some accepting different. As an example, arbitration tax issues settlement through arbitration, India never accepted. Other countries accepted. So what I'm trying to say, sir, just maybe Prashant ji, please correct me. So it was not necessary for any country to accept all clauses of MLI or all clauses of BEPS. There was a minimum mandatory standard which was to be accepted.
Minimum
Yes,
standards. They've
yes.
accepted this.
That to that extent, yes. And even some countries didn't accept even that minimum standard. I think
Correct.
Yes, yes.
Mauritius, for example,
Some,
and
Pending. They've not
I mean,
agreed.
there
I
are
mean,
there are instances, sir, like you have called out those countries which have not called out India, and with respect to those countries, the MLA is in any way not operative. So
No,
it
not
not
does
operative.
not.
open.
I
So
think
this answers
we need to have some separate session on understanding the nitty-gritty of these MLI notifications.
Sir,
Yes, yes.
in fact, sir, just to complete Panu sir's point, I think this notification is a subsequent thing. The antecedent thing is the working and structure and development of MLI and the precedent steps. So I think understanding that would be perhaps a better input to understand the later this synthesized text or notification.
Because
Sir,
frankly,
the
if that be so, then we may have to end up a different decision altogether.
sir,
So
Because that is
actually,
what
if
is very crucial.
double taxation avoidance agreement is no different than the investment treaties, no different than other member state treaties. It is
right.
merely related to tax, and therefore we are discussing this, sir. If you look at the SARC treaties entered into with, say, 6 countries, did India issue 6 notifications? No, only one notification. SOC agreements. Did India issue
No, no,
six
no.
notifications?
Prashant,
No.
that is not the point. We are
Uh,
only looking at the specific act which governs this. That is
so,
section 90, subsection
Yes.
1.
so
Other
there is one agreement, one notification, sir.
correct.
नहीं सर
But
just
there has been amendment to that agreement.
नहीं
There
सर
is
सही
no
कह रहे हैं पन्नू
amendment.
साहब
There is a
पन्नू साहब सही
modification. There is a modification to the other
It is
earlier
also
agreement.
argued that it is no agreement. There is no amendment to the agreement. There is no
Let it be
modification to the agreement.
okay. If so with the modification, then यार
Sir, ये
modification है तो agreement ही ना यार कुछ भी कहो. What is there?
नहीं
so,
But the
sir,
fact
the both
because
sides,
that
the arguments are very heavily loaded.
नहीं
very
सही कह रहे हैं
loaded. So
सही
but
Very
section
heavily.
90, that is why I thought that let us look at section 90. Section 90 talks on agreement.
Hmm.
That's why I wanted to go on the word agreement. Agreement need not have a kind of a preface of a kind of word of a protocol or a modification of an agreement. It will be certainly, if you want to change, you have to agree to the change. The
But
requirement of 91 is that whatever you agree to should be notified.
But sir, when the central government is already entered into an agreement and it is signed, central government has not entered into an agreement further to that, sir.
So
Therefore,
that
there is a
how
therefore there is a
how the
uh,
arm of the central government, the department, is utilizing that on the strength of Section 91 implications.
mm,
These are questions which will arise.
mm,
Therefore, that's what I'm saying. We have to go into the nitty gritty of what the MLI was,
Yes, sir.
how it is
mm.
the operating. Because if we were to say that they have been notified after having agreed upon,
Uh,
then the whole thing changes.
but one thing to be noted, sir, in this
Yeah.
judgment, CBDT lost an opportunity
Absolutely. I think
to
everybody lost.
satisfy to
Everybody
satisfy
lost.
the ITAT,
Mhm.
Correct.
to give the clear-cut picture. Their
Agree.
representation was so scanty.
Bilkul.
And actually, this would have been because they did not see, despite the tribunal giving enough opportunities, that we
Hmm.
would be saying so if you do not come out. And
Correct.
despite this, disability was lax in the approach. That is what is more painful.
No, the point is the DRP said took a different position, the board ultimately took a different position. So that's something very surprising.
Yeah.
So therefore, probably, I think Agarwal sahab, perhaps you can decipher this that they know they are probably they are on the weaker wicket because of the lack of some notification.
To my mind, sir,
No, sir.
because
1 second.
Uh,
Was this issue before the DRP regarding
mm,
the notification?
No, no, no.
It was
I
not
no,
there.
no,
Ah,
Notification issue was not there before the DRP.
not at all. Not at all. It was a
no,
new issue
no.
taken by the SSE.
Agreed. But what the DRP said was that it is an amendment to that agreement.
No,
oh,
sir. That was stated by CBDT in response to the query by the bench that you
The
submit the
boards,
submission.
no, board said that it is not an amendment to agreement.
Ah, yes. CBDT said so.
And DRP said that yes, it's an amendment. You see, that's what I'm trying to say. That's why I agree with you that they lost an opportunity to bring out the entire thing,
Mhm.
especially in the context when this dichotomy was taking place. वही तो मिस्टर शर्मा ने explain किया ना अपनी presentation में the dichotomy between what the DRP, the Revenue Authority said and what the board has said ultimately said. शर्मा जी, why can't you explain that further थोड़ा
सर
दोबारा?
सर वो नोटिफिकेशन का इश्यू डीआरपी के सामने था.
नहीं
Sir, order said nahi. So if you look at the order,
Ah,
there is no issue of notification. In fact, DRP
yes.
proceeded and it was taken before the tribunal for the first time.
First
Correct.
time, yes.
No. But the nature of that modification, or the nature of reading her along with that, what the DRP said is an amendment. What do you think, Mr. Sharma? वही तो आपने बोला ना उसमें amendment तो कहा ना उन्होंने?
So if you see the what I've written here, so effectively the DR seems to be agreeing that when you read MLI, the treaty provisions, the applicability of the treaty provisions is getting amended, and this is what the tribunal caught hold of and said that if you are trying to change the implementation, you are saying that the treaty is modified. And if I am to look at the way Supreme Court ruled in case of Nestle, then that notification also needs to be notified.
See, the difficulty is that in page 18, the tribunal reproduces the submissions of the CBDT after the. Now, I'll just read that one para. That is para 3. And the last sentence of this paragraph. The MLI is a multilateral tax treaty that serves to modify multiple bilateral tax treaties based on reciprocal notifications by the respective treaty partners. Now, if you take this position, you will have to show that where is that treaty notification which you have agreed upon with the respective countries.
Reciprocal here.
Reciprocal, and in there using the word by respective treaty partners. So therefore, मतलब and they जो अग्रवाल साहब ने जैसे he argued look, it can have a for a consolidated or can be notification also there. Even that argument is not taken by them before the bench. तो थोड़ा as you rightly said कि well thought out नहीं है revenue stand here.
सर एक चीज देखिए, जस्ट सर यू परमिट मी,
जी
ये
जी
सेक्शन 90 में जो अमेंडमेंट हुआ था क्लॉज बी में, आई एम जस्ट रीडिंग कि इसमें 14 दिस वाज अमेंडेड बाय फाइनेंस एक्ट 2020 विद इफेक्ट फ्रॉम 1 अप्रैल 2021.
करेक्ट.
अब इसमें जो क्लॉज बी है, ऑल ऑफ यू आर एक्सपर्ट्स, सो आई एम नॉट रीडिंग एंटायर थिंग, फॉर द अवॉइडेंस ऑफ डबल टैक्सेशन ऑफ इनकम अंडर दिस एक्ट. and
Yes.
under the corresponding law in force in that country or specified territory as the case may be. Now, what they have added, without creating opportunities for non-taxation or reduced taxation through tax evasion or avoidance, including treaty shopping arrangements aimed at obtaining reliefs provided in the said agreement for the indirect benefit to residents of any other country or territory. Now, this has been added by Finance Act 2020. This is under Section 90, subsection 1. Now, will it not qualify as a notification, which the Supreme Court talked about in Nestle?
Sir, if I, so, okay,
Yeah.
is the question that because the section 90 now has this language, the
Hmm.
MLI notification is also should be considered as a notification in section 90 because of this new proviso?
To my
if
mind,
you-
because it has been done at a mass level, na? The MLI is a
if you-
mass level instrument.
But
So
if you
they
see,
have
sir, that notification was brought in 2019. This amendment came later. So,
yes.
by that argument, that notification would lose, it can't have legal sanctity because the amendment was introduced at a later point of time.
I think one more thing, coming from revenue side, and I have written so many amendments to the Income Tax Act which are still operational. I mean, that government, nothing prevent the government from making some amendment to this section retrospectively, because to me it appears more hyper technical rather than any substantive thing.
And
I
I
mean,
think
just
if
fair point. That is the point I feel.
That's a fair point.
Yes, this is very technical, and possibly that is the reason why, if you look at the order, after ruling on this legal issue, the tribunal then goes on to the merits of the case as well, because the tribunal says that because the DRP had passed such a detailed order dealing with different aspects of PPT, they also get into the merits of the case. And with your permission, if it is okay, I can move on
No,
to
no,
the.
I have just one last thought on this. Mr. Agarwal, can you, if you rightly put it, that amendment of 21, but if we complete that sentence with the last sentence of the same provision after subclause D, and may by notification in the official gazette make such provisions as may be necessary for implementing the agreement. So the substantive part of 2091B, and read with this last sentence, makes it that to operationalize and implement, perhaps that notification is required.
And Panu sir, as I was saying, that notification which the department is trying to say is the valid notification came in 2019. This amendment came later. So by that logic, after this amendment, if you need to notify everything, somebody may argue that that notification of 2019 itself does not survive. Because how can you have a notification when I'm not saying if
I
we were
think,
to
sir,
look at it like that.
with respect, sir, सही
Yes.
कह रहे हैं, sir. Panu sir, 90
Yes.
में जो that portion which we both of us read, that is one part.
Correct.
And after that, sir, after clause D, please see, and
Yeah.
may by notification in the official gazette.
Correct.
So
Correct.
additionally, it is saying additionally.
Yes.
Law is only, the amendment is enabling,
Yes. Yes.
which enables the issuance of subsequent notification.
Exactly.
Yeah. So perhaps
Correct.
maybe that may be the right view, but
वो थोड़ा ये so थोड़ा था. That's what I'm saying कि we should understand MLI notification exactly है क्या, what it is contain, at what stage it is issued, under which power of they have issued, what is the preamble vis-a-vis 91 requirement. वो सारा एक बारी किसी सेशन में बैठ के करना चाहिए.
मेरे ख्याल से, मेरे ख्याल से.
Yes, sir.
That will be very useful.
That will be very useful. What do you say, Prashant bhai?
Yes, sir. Now we have a very interesting discussion, sir. We have very less time here, but we do not want to miss the opportunity of presence of Agrawal sir, who has done a lot of work on the self-drilling, sir. And it was a spillover matter since last our earlier discussion also. Will I like to go through this part here? If chairman permit.
अभी 7:20 तो हो गया है प्रकाश.
Yes, sir. Yes, yeah, I totally agree, sir.
और ये 1 घंटा एटलीस्ट लगेगा, क्योंकि उसमें तो वर्क इन प्रोग्रेस है. अग्रवाल साहब तो अभी ड्रिलिंग कर ही रहे हैं उसमें. अभी स्पेशल बेंच के सामने जाएगा.
Sir, in fact, with Panu sir's permission,
Sir.
in fact, I was more interested, and subject to the group's convenience, this main issue of this sky high, that is aircraft leasing, finance lease or operating lease. This is a real interesting issue, which I would love to share with the group, maybe today's slide briefly or maybe some other time, because that is the, once you understand that, because this issue, maybe department is, so department is also not somehow, because officers change and there is, I mean, I may say something, some few pointers only today, maybe for some other session, that this treaty shopping, MLI notification, all of them are absolutely irrelevant to the matter on merits in that case, sky high.
Oh.
Absolutely irrelevant, because that we say Ireland leasing companies, that there is no leasing, sir. I give you an example. Just think of carefully. I just want to make it more lively this session now. I give on one group, on one side there is a group of names I speak, and then on other side I speak a group of names, and just then I want all of you to think quickly. On left side I have a group: Air India, Indigo, British Airways. This is one group on my left side. On the right side there is a group called Mahindra Lease Finance Limited, Birla Finance Limited, Tata Finance Limited. These are all non-banking finance companies.
Correct.
Now, between Air India and Mahindra Lease Finance, do you see any similarity?
No. No, sir.
Obviously
Both
not.
of them.
Obviously not.
Both of them are engaged in some business, but
Correct.
otherwise there is no similarity. So, these Ireland-based companies, leasing companies, they fall in the category of Mahindra Lease Finance, Birla Finance, and Tata Finance. They do not belong to the category of Air India, Indigo, British Airways. These are pure and simple NBFCs. And what happens quickly, I'm just, Pannu sir and everybody is so senior and experienced. What they do, sir, I give you, because I have done entire surgery of them.
Got it. So we're trying to say they are not aircraft companies.
Not at all. They don't
only
know.
with capital.
Yes, that's all. In fact, this Sky High Leasing or that SMBC Finance Limited, these are all high court. Their matters are in public domain now. So all of them have happened. And I have seen as a surgeon,
There is no capital also, sir. Capital has also come from US.
No, I mean,
most of them,
correct.
Generally,
they are having capital. I didn't say they did not own the capital.
These are basically this general
Sir, what is the issue? Now the main crux of the issue is what is SPV?
Exactly.
Why SPV is?
मैं बताता हूँ आपको. I am like the surgeon who has done the surgery on this. So मुझे कुछ देखने की जरूरत ही नहीं है.
तो मैं तो Agarwal sir, can I suggest something?
हाँ जी.
Prakash, this topic will be very interesting.
Yes, sir.
I think we should give Agarwal sir at least 1 hour one day.
Yes, sir.
Maybe with a few slides we can assist.
Numbers and everything. I would. Yeah. I mean, this is not. अरे आप कार का लोन जाते हैं ना, कार का लोन लेते हैं
सर आपसे दो विनंती है अग्रवाल साहब.
हाँ.
एक तो ये एसपीवी का स्ट्रक्चर आयरलैंड में ही क्यों है?
मेरी बात सुनिए.
नंबर 1. और दूसरा भी मुद्दा है. दूसरा मुद्दा है कि आयरलैंड रूल का जो 110 है, आयरलैंड इनकम टैक्स सेक्शन, क्या ये सही बात है कि एसपीवी इज टैक्स फ्री? देयर इज नो टैक्स ऑन वैट, देयर इज नो टैक्स ऑफ वैट, देयर इज नो इनकम टैक्स, देयर इज नो अदर टैक्स ऑन एसपीवी. ये दो बातें हैं. 110 is the ruling of the Ireland tax authorities. SPV is tax free.
I will supplement what brother is saying with a question.
Sir.
How does Apple's worldwide billing 70% is from Ireland?
Sir, that is what it is.
Sir, आप just मुझे 2 मिनट दीजिए. आयरलैंड में कॉर्पोरेट टैक्स 12 या 12.5% है. As compared to our India 35-40% जो भी है.
कॉर्पोरेट टैक्स नहीं सर, एसपीवी टैक्स.
मेरी बात सुनिए, मैं बता रहा हूँ आपको. एसपीवी में 110 does not apply to this Apple वगैरह. 110 applies to only this aircraft leasing kind of thing.
Correct.
जिसमें की जो इनकम आती है रिसीट्स वहां पर, उसके
हाँ
अगेंस्ट एक्सपेंडिचर, बिकॉज आयरलैंड कंपनी डज नॉट ओन द कैपिटल. The capital is submitted, furnished by General Electric USA. The
जी
95% of them are the subsidiaries. Subsidiaries नहीं है,
जी
पोस्ट बॉक्स कंपनीज है, पोस्ट बॉक्स कंपनीज,
जी जी
एंटिटीज जिनको बोलते हैं वो उनकी.
जी
तो होता क्या है कि जो भी आयरलैंड में आता है, मैं आपको एग्जांपल बता रहा हूँ ना, नंबर बता रहा हूँ आपको, मतलब यू विल लव इट. एक एयरक्राफ्ट $40 million का आता है, एयरबस 320, $40 million, दैट इज अ फिक्स प्राइस. उसको खरीद लिया इन्होंने. किसने खरीदा? इंडिगो खरीदता है. इंडिगो जाकर एयरबस के साथ एग्रीमेंट करता है और उस एयरक्राफ्ट का डिसीजन लेता है. इंडिगो उसमें से 10% मान लीजिए एडवांस डिपॉजिट देता है, 90% वो लोन लेता है, क्योंकि नोबडी वांट्स टू, इतना पैसा किसी के पास नहीं होता है.
Correct.
अब 90% जो फाइनेंस करना है, इसके लिए दे गो टू समथिंग कॉल्ड महिंद्रा लीज फाइनेंस. महिंद्रा लीज फाइनेंस का इक्विवेलेंट है ये आपका स्काई हाई लीजिंग. स्काई हाई लीजिंग, स्काई हाई लीजिंग इज ए प्योर एंड सिंपल लेंडर. ये आपको $35 million का लोन देता है, ठीक है, और $35 million की 12 साल की किस्त बांध देता है. ईएमआई, ईएमआई, उस ईएमआई में आप $3,50,000 पर मंथ की ईएमआई देते हो. रिटर्न ऑफ द प्रिंसिपल प्लस इंटरेस्ट एट द रेट ऑफ 4% प्लस 2.5% ऑफ द लाइबर, इसको ऐड करते रहते हो. इस तरह इंटरेस्ट पे करते रहते हो. This lender who is masquerading itself, I mean, I'm using the word masquerading as a leasing company. It does not know how where to enter from in the cockpit of the aircraft. It does not know. It simply says that भैया आपको जो एयरक्राफ्ट खरीदना है, बोइंग से खरीदो, इससे खरीदो, कुछ भी खरीदो, हमको क्या मतलब है? हमको तो लोन देना है, लेंडर है हम तो, और हमको सिक्योरिटी चाहिए. सिक्योरिटी एयरक्राफ्ट खुद होता है. सो दिस इज द वे इट हैपन्स. एयर इंडिया वगैरह इसमें जो ऑपरेटिंग लीज की बात कर रहे थे, फाइनेंस लीज की उसकी बात कर रहे थे, वेट लीजिंग, ड्राई लीजिंग, वेट लीजिंग, ड्राई लीजिंग, वो आई विल सेपरेटली ब्रीफली टच इट. व्हाट इज वेट? दिस हैज नथिंग टू डू विद लीजिंग. लीजिंग वो होती है कि एयर इंडिया के पास आज 300 एयरक्राफ्ट है. आज कई बिजनेस क्या होता है, अप एंड डाउन होते हैं. पता लगा सडनली यूरोप में डिस्टर्बेंस हो गया, यूरोप की फ्लाइट्स कम हो गई, तो कुछ फ्लाइट एयरक्राफ्ट लैंड हो जाते हैं, मतलब लैंडेड हो जाते हैं. At that time, some other airline in some other country might be needing the aircraft. Temporarily, Air India उसको lend कर देगा. That is called wet leasing or dry leasing, subject to their terms. Air India will take back those aircrafts when its demand picks up. Here, money has been lent, not the aircraft, nothing. The time value of money is being recovered. The consideration is that in a operating lease, all of you are knowing that the lease, as an example, I take a house on rent. I take a house. I pay to the landlord the monthly rent. I am not concerned what is the cost of the landlord in acquiring that house. It was his gifted house, inherited house, self. हमको कोई मतलब नहीं, हम तो market value दे देंगे. So what I mean to assets earning capacity is the payment to the lender. Ownership is always the lender, and user rights are with the borrower. I mean lessee. Here, the ownership is the lessee. All the rights are with the lessee. If the aircraft is destroyed, the lessee is the loser, not the lessor. Anyway, so just I wanted to give a premier
I
type.
just want to I want to add to what I just want to put a caveat here. While the arguments, Sunil sir, which you are making in this order, none of those arguments are forwarded.
No. This
Because
is not progress.
Because
so-
this issue now इसमें एक और issue है, just to complete, क्योंकि I am
नहीं
dealing
नहीं
with
this
some
issue
earlier
is
years.
concluded by the Supreme Court. Even SLP is dismissed.
yes.
Even
नहीं,
SLP is dismissed.
सर
वो जो हुआ हो.
नहीं, प्रशांत जी बोल रहे हैं ना.
जी.
हाँ प्रशांत जी, जो सुप्रीम ने कोर्ट ने कंक्लूड किया है, सेक्शन 10 सबसेक्शन 15A ऑफ इनकम टैक्स एक्ट, उसकी कहानी है ये. 2007 में उसमें अमेंडमेंट हुआ था. इसके पहले सर क्या होता था, दैट इन द इंडियन, दिस वाज ए इंसेंटिव प्रोविजन बाय द गवर्नमेंट ऑफ इंडिया. द इंडियन एयरक्राफ्ट इंडस्ट्री वाज टू बी promoted. So if they acquired the aircraft from foreign sources and then paid the rent, etc., whether it was equipment, operating lease or finance lease, this was exempt from tax in India because of notification by CBDT issued under section 10 subsection 15A. That was the position. In 2007, this law was amended, and this exemption from income tax act section 10 was taken away. So now it is no longer there. Now, if you want an exemption, it is only in the India-Ireland Treaty. India-Ireland Treaty exempts operating lease under the Article 12, that royalty clause. Operating lease. This is finance lease. Here the interest is taxable in source estate under Article 11. So here the treaty,
Sir, you say
that is the
we
case.
also understand. But in this case, if you read paragraph number 98, the assessing officer himself accepted that it is an operating lease.
नहीं वो एक्चुअली वो उसमें देखिए बहुत से कंफ्यूजन हैं वो हम सब
हाँ,
चीजें
तो मतलब
कोशिश
अब
कर
एसेसिंग ऑफिसर ने कंक्लूड कर दिया
Sir, I'll so I'll just want to add to what Maharishi sir is saying. When they allege that this is a P, effectively, if you read now, because we are talking about finance lease, in
पी
while
नहीं बनता
alleging that this
पी
is a
नहीं
P,
बनेगा पी नहीं
they
बनेगा
say,
नहीं
so
बनेगा
the department says that aircraft is at the disposal of the foreign lessor.
Yes.
And when they come to finance lease, they reverse the argument and say
Yes.
ownership is, I mean, you.
Yeah. That's
So
contradictory. That is
that may
contradictory.
be
very
that may be
contra-
wrong
This
that
self-defeating.
may be
may-
wrong that may
But
be wrong
I have one thing. What I also one issue which strikes me. A NBFC, can it not have the business of leasing also?
मैं बताता हूँ क्या करती है लीजिंग कर सकती है लीजिंग में वही इसमें क्या आता है लीजिंग कर सकते हैं आप लीजिंग एक होता है फाइनेंस लीज और एक ऑपरेटिंग लीज विच वी विल हैव टू कवर इन सम अदर सेशन बिकॉज टुडे ऑलरेडी
Correct.
हाँ वी विल कवर इट आई वुड गिव यू दैट जो सर्जन रोज सर्जरी करता है वो काम मैं कर चुका हूँ इसमें सब में और वो सब कोर्ट में है ऑलरेडी
Yeah,
200 से ज्यादा है फिर जब मेरा मैटर देखा तो फिर मिस्टर एन वेंकट रमन एएसजी हैं डिपार्टमेंट ने उनको कहा कि भी ये मैटर बहुत बढ़िया है तो लेट अस रिप्रेजेंट इट दिस वे तो पूरा का पूरा तो मैं आप पूरे ग्रुप से शेयर करूंगा इट इज पार्ट ऑफ पब्लिक डोमेन नाउ आई मीन हु आर द लेंडर्स something called Sumitomo Mitsubishi Banking Corporation, Sumitomo Mitsubishi Banking SMBC.
Correct.
That is the
Correct.
lead case, which is my case. Now, a banking corporation, that is a lesser. So they have no. This is a entirely different world altogether. Sometimes department also doesn't understand. In fact, I had I should not. These are internal discussions. I am a senior standing counsel for income tax in High Court and other places. So I have to interact with the departmental authorities, and sometimes it becomes difficult for me to also explain to them that when I came to know the department is using treaty shopping, etc., I told them that here treaty shopping वहाँ होती है जहाँ treaty honestly apply होती है, आप dishonestly apply करने लगते हो. treaty shopping वहाँ होती है. जहाँ treaty लगती ही नहीं है वहाँ treaty shopping क्या? यहाँ तो ये लीज ही नहीं है ये तो इंटरेस्ट पेमेंट्स हैं दीज आर इंटरेस्ट पेमेंट्स आर्टिकल 11 में आते हैं तो ट्रीटी लगाओ मत लगाओ रिजल्ट इज द सेम इट इज टैक्सेबल अंडर द इनकम टैक्स एक्ट
You are right. You see,
so
first of all,
Sir,
they should do the characterization first. कि भी है क्या? I appreciate. But वो तो factual driven है ना फिर.
नहीं फैक्ट
those
सबके
are
एक जैसे हैं
facts.
एक फैक्ट सबके एक जैसे हैं एग्रीमेंट इज अ टेम्पलेट एग्रीमेंट बिकॉज इट इज गवर्न्ड बाय एन इंटरनेशनल कन्वेंशन और इंटरनेशनल कन्वेंशन को वो 2018 की कन्वेंशन है 18 की नहीं और भी पहले की है इंडिया ने उसको लॉ भी बनाया था टू गिव इफेक्ट अंडर आर्टिकल 250 ऑफ द कॉन्स्टिट्यूशन बट समहाउ लॉ पास नहीं हुआ देयर इज इंटरनेशनल कन्वेंशन फॉर एयरक्राफ्ट लीजिंग बिकॉज aircraft is a very expensive instrument, an expensive thing. And let us say somebody gives aircraft, funds aircraft from Europe to India. India is a now sound economy. Now somebody lends an aircraft to Pakistan. अब पाकिस्तान कैसी इकोनॉमी है किसी को पता नहीं है कल को उसका एयरक्राफ्ट किसी कंट्री में जाके अरेस्ट हो जाएगा क्योंकि पाकिस्तान ने लोन रिपे नहीं किया है नाउ व्हाट विल हैपन टू द लेंडर so these are the तो लेंडर वांट सिक्योरिटी कि भैया अगर आपने लोन का रिपेमेंट नहीं किया तो मैं अपना एयरक्राफ्ट वापस ले जाऊंगा क्योंकि दैट एयरक्राफ्ट इज रजिस्टर्ड बाय अंडर डीजीसीए विद इंडिया एंड इन केस द बोरोअर लाइक अभी कौन सी कंपनी थी वो कुछ कंपनी है ना प्रकाश जी जो कि थोड़ा वीक सी हैं अपना जो कि कभी कभी उनकी प्रॉब्लम आ जाती है
जेट के साथ भी ऐसा हुआ था
हाँ जेट के साथ भी हुआ ना उसके बाद
स्पाइस जेट के साथ भी हुआ
स्पाइस जेट हाँ तो ऐसी कंपनियां जब उनका क्या होता है दैट एयरक्राफ्ट हैज टू बी एक्सपोर्टेड इट इज कॉल्ड एक्सपोर्टेड आफ्टर डी रजिस्ट्रेशन विद डीजीसीए इस टाइप की चीजें होती हैं बहुत इंटरेस्टिंग सब्जेक्ट है ये सो मतलब मे बी सब्जेक्ट टू द ग्रुप्स कन्वीनियंस जब भी आप लोगों को लगे
एब्सोल्युटली
सर एक इश्यू ये भी है कि इफ इट इज इन द एयरक्राफ्ट लीजिंग Why only two countries, China and Korea and India?
Sorry.
So basically, there are three countries,
Yeah, yeah.
China, Korea and India. ऐसा क्या है आयरलैंड की ट्रीटी में चाइना, कोरिया और इंडिया के साथ कि उसी के एयरक्राफ्ट वहां से लीज हो रहे हैं?
सर,
और
मैं बता
कंट्रीज के नहीं हो रहे।
मैं बता रहा हूँ इसकी वजह ये है, आयरलैंड की ट्रीटी में एक सेपरेट क्लॉज है सेम जो कि आर्टिकल 12 में है ना, उसमें दो क्लॉजेज हैं बेसिकली देयर इज ए समथिंग कॉल्ड एसोसिएशन ऑफ लीजिंग इंडस्ट्री ऑफ आयरलैंड। जैसे हमारे यहाँ फिक्की है, चेंबर ऑफ कॉमर्स वगैरह होते हैं ना, इस टाइप की एक बॉडी है, कॉमर्शियल बॉडी ऑफ द। उन्होंने आयरलैंड की पॉलिसी है दैट आयरलैंड मस्ट बी द हब ऑफ एयरक्राफ्ट लीजिंग, दैट इज ए गवर्नमेंट पॉलिसी। तो दुनिया भर के जितने भी एयरक्राफ्ट चलते हैं उनकी फाइनेंसिंग अबाउट 75 to 80% हैपन्स फ्रॉम आयरलैंड, दैट इज ए स्टेटिस्टिकल फिगर। नाउ विथ सम कंट्रीज द ट्रीटी ऑफ आयरलैंड इज नॉट गुड। आयरलैंड की ट्रीटी में दो खास खूबियां हैं। उनकी ट्रीटी का इस तरह से रहता है कि पी नहीं बनेगा अंडर आर्टिकल 8। उनका पर्पस क्या है, दैट नो दिस आर्टिकल 8 ऑपरेट्स, ऑल ऑफ यू नो इट, that a person who is engaged in the operation of aircraft of carrying business
International
of carrying
traffic.
passengers or aircraft in international waters,
International
the
traffic.
person in that international traffic or shipping, the business must be of the income derived from the operation of passengers or cargo in international traffic.
Yeah.
That is subject of exemption under Article 8, right? So now this person is a airline. Airline can be an owner of aircraft or it can be a lessee of the aircraft. Now उस treaty में ये है that the benefit can be given even if the lessor is not itself engaged in the business of operating the airline, provided the lessee is operating the airline.
Okay,
So
okay.
that is the essential condition. And to understand this, I will take you people. In fact, USA Ireland की treaty along with their explanation, that gives the entire history of this reversal, role reversal, कि जो normal understanding हम लोगों की है OECD की या
Sorry for interruption, sir.
I'll make a
Pannu
small
sir.
point.
जी,
Sorry,
जी.
sorry, Mr. Prakash, before you come back. So while Mr. Agarwal is right, Article 8 is differently worded. What I was trying to speak at the start, Article 8 of India-Ireland Treaty is not based on the OECD model. Unlike other treaties, it clearly includes rental of income. And in fact, what you were saying, that is what the department also tried to do while adjudicating on the issue of Article 8, that AO and DRP seem to have relied on OECD article, which is not there in the India-Ireland Treaty. And that is what the tribunal also found in this order, that if you look at the India-Ireland Tax Treaty, not just operations, the rental income is also covered. And therefore, the benefit cannot be denied. I take your point. It is a very interesting discussion and should be had.
In fact, प्रशांत जी का पॉइंट था कि ऐसा
सर
arrangement
इस एग्जांपल में
होगा
ना,
between Ireland, China, Korea, and India, which will give them this. Why only these three countries have been?
My limited knowledge.
answer you, Ireland itself has signed this treaty, this clause of exempting the CIS equipment royalty from taxation. This is Ireland signs this kind of treaty with some 80-90 countries in the world. They have already signed.
Okay. Achha, the others also.
Yes,
So-
yes. Only few countries are remaining. They are negotiating with them also to make it a hub of aircraft leasing, what they call it.
Pannu
But
sir,
the treaty,
I
Yes,
think that we should have a separate session on this topic, sir. Rather,
I am open for it. You organize it. Agarwal साहब से time ले लीजिए अग्रवाल साहब से.
because the way the discussion is going on, I'm very sorry to say, because we are already 7:45 and I
No,
received
let
the
us. We can.
Saurabh Sharma sir, because
Yeah.
Saurabh Sharma sir right now is in Dubai, and
No, let him.
he is joining from Dubai here, and he has told me that he has to catch the flight here, sir.
No. Let us not detain him. I think.
Yeah.
Let us now try to. I think you can thank everybody and we can close it fast also.
Yes. I'm so with the permission of chairman, sir, may I extend the vote of thanks to all, sir?
Yes, please kindly, because we are getting
Yeah.
out of time.
I'm really on behalf of the Chamber of Tax Consultant, I'm really thankful to all the learned speaker here. Parsa कहते हैं Saurabh Sharma sir for sparing you his valuable time and making presentation. And I'm very glad to say that when I spoke to him, he was in USA. And he readily agreed that, okay, he will be making the presentation. And he has come to Dubai. And from Dubai, he is making this presentation here today here. Uh, Agrawal Saab is always a very helping hand to me here. I'm really blessed with him. Whenever I have requested, sir, your split session is coming up here. He has already agreed here. But today, again, we have to keep the split session pending and pending right now here. And on behalf of the chamber here, I'm really thankful to our chairman, sir, Pannu sir, for blessing us with so much wisdom here. And I think that all have benefited here with his presence here. And really, Prasant Mercy sir input has made a very lot of changes here. His inputs has created a lot of debate here. And I'm really thankful for Mercy sir, Vijay Goel sahab sir, who has contributed here. And I look forward for this type of session. And with the permission of Chairman sir, I have already requested Agrawal sahab to have a very good session on the Article 8 with the finance lease and the operating lease here, which will give a learnings to all of us, sir. I hope that Agrawal sir will be blessing us with this thing, sir. Yeah.
Yes.
Whenever you
also,
feel convenient, group convenience, Pannu sir and everybody's convenience. That is
and
important.
Prashant ji से भी बात कर लेना.
अरे
Yes,
हाँ.
sir.
So that Prashant ji should also join at that time when Agrawal Sahab is making that presentation.
And
Sure, sir. Thank you, sir.
प्रशांत जी वैसे होंगे, वीडियो ऑन रहेगा उनका.
उनका वीडियो ऑन रहेगा.
With a request to Prashant sir.
It will not make any further impact, sir.
With the permission of Chairman sir, I
Thank
will
you
say
very much, everybody.
thanks to all, and wish you a very happy Navratra. Wish you a happy Navratri Garba. Prashant Mercy sir, Garba sir की बहुत बहुत शुभकामनाएं सर आपको सर.
Jai Bhavani, sir. Thank you.
All the best. All the
जय
best.
भवानी.
Thank you.
Thank you, sir. Thank you, sir.
Good night.
Good night. Good night. Thank you.